Welcome back. We continue our consideration of the Education Scotland Bill at Stage 2, Day 2, and we will move straight to our proceedings. And I call Amendment 131 in the name of Miles Briggs, in a group of its own, Miles Briggs, to move and speak to Amendment 131. Mr Briggs.
Thank you, Convener, and welcome back, everybody. From the first session this morning, I do welcome the Cabinet Secretary's amendments in relation to BSL. This is something I know cross-party we had raised, so very much welcome those. But I wanted to bring Amendment 131 in relation to additional support needs. The recent Audit Scotland report in February really did point towards what needs to be a fundamental review of needs and planning and resourcing for ASL. So this amendment, which I brought forward, comes from a number of discussions with teachers and parents and pupils themselves over the bureaucracy surrounding additional support for learning. I hope that this will present an opportunity to simplify those who do need additional support. Currently, each teacher is asked to provide evidence, and this will simplify that to just one teacher, be it the head teacher, and that's something I hope will make a real difference in the guidance going forward. I hope this is a helpful reform, and also potentially this can present additional improvements to be brought forward ahead of Stage 3 as well, because I'm sure members may also have other learnings they would want to bring ahead of our Stage 3 proceedings as well. So I move the amendment in my name.
Member take an intervention?
Yes. Yeah.
Thanks, Mayor. I'm grateful to the member for taking the intervention and also for allowing us to have a debate on this issue. I'm just interested, I'm not quite clear on the rationale around the role of a head teacher here, because it appears from my reading the amendment that it would have to be the head teacher who is supervising any pupils with additional needs who are getting extra time. And I'm not convinced that's the best use of a head teacher's time in a high school setting, but I'm also particularly concerned given that some exams, that given the timetabling of exams and the very, very high proportion of pupils now with a recognised additional need, whether it would actually be practically possible, even if we did feel the head teacher was the most appropriate individual.
So the rationale for that in the wording of the amendment was head teacher signing off that support would be provided instead of evidence being provided by each teacher. I'm sure the Minister will come in at some point if there's wording around this which needs to simplify that or correct it. Happy to take that forward. Yes,
Pam Duncan-Glancy.
I thank the member for taking an intervention, and I am supportive of this amendment in principle. I think that there are a couple of potential amendments to the wording that might address the point that Ross Greer makes, but also in clause 1. In clause 2A, the circumstances where the person undertaking an examination may receive additional time. I wonder if that is something that would be set out for Qualifications Scotland, or if that is something that's very bespoke and specific to the individual. And so I think what's probably important is that these things are recognised, but I wondered if the member would consider working with myself and others to bring this back at Stage 3.
Miles Briggs.
Absolutely, happy to do that. I was hopeful that this would actually have other potential amendments from other members as part of it, because there's other issues I think could also really benefit the bill. So more than happy to do that. I think probably the support within the government party as well on this. So hopefully there is an opportunity to maybe widen this offering in the bill at Stage 3. I think it's very important when we look at the number of pupils with additional support needs in our schools that actually these new organisations embed that as well. Thank you, Convener. Thank you.
Cabinet Secretary.
Briggs for explaining the purpose of his amendment, and I agree with the sentiment behind ensuring Qualifications Scotland provides guidance on arrangements that can be made to assist those with additional support needs when they're being assessed for qualifications. However, I'm not clear about the member's intention in requiring anyone that has been given additional time for exams to be supervised by the head teacher, which is, I think, the point that Mr Greer was making. So Amendment 131, as drafted, is very restrictive and it is likely to prove unworkable in practice. So, for example, it doesn't take account of circumstances where the head teacher is absent and does not specify who would be a suitable replacement. So the amendment also does not allow another head teacher to step in, as it specifies it must be the head teacher of the educational establishment at which the examination is being undertaken. So we can foresee risks around scheduling and bottlenecks, which would be pretty unfair on school administrators, teachers and most importantly on pupils with additional support needs. However, I do recognise Miles Briggs' desire for more assurance in this area, so I'd be happy to work with the member on this ahead of stage 3, and on that basis I would ask Mr Briggs not to press this amendment.
Thank you. I call on Miles Briggs to wind up and press or withdraw Amendment 131. Mr Briggs.
Thanks, Convener. And having reflected on it, I think there are drafting points and also potentially some opportunity to also bring some additional amendments in this. So happy not to move at this stage and to work with ministers and others ahead of stage 3.
Thank you. Miles Briggs seeks to withdraw Amendment 131. Does any member object? No member objects. Amendment 131 is withdrawn. I call Amendment 280 in the name of Ross Greer, grouped with Amendments 282, 35 and 71. Ross Greer to move Amendment 280 and speak to all amendments in the group. Mr Greer.
Thank you, Convener. Good evening, everyone. The first of the amendments that I've proposed in this group is trying to address what I see as one of the issues that's led us to this point in relation to the relative passivity of the board of the SQA. I think there's been significant improvements recently. Board culture has improved. The new chair has certainly had a transformative effect. But many of the issues that have led us to this point could and should have been effectively scrutinised and indeed in some cases prevented by the board of the existing Qualifications Authority. And that didn't happen. At points in recent years, the board has not played a particularly active role, certainly in relation to decisions related to the delivery of qualifications, matters of education policy. I think the board has been mostly adequate in relation to corporate governance. But what I'm proposing here in 280 is that the board would have to actively approve the corporate plan. It forces a vote on it. And that is to make sure that the board, it's to give the board a firm nudge, but certainly to make sure that ultimately they are actively agreeing to rather than just passively nodding through.
Would the member give way?
Yes.
John Mason.
Yeah, I thank the member for giving way. I mean, I take his point, but I mean, I go to many meetings, and I'm sure he does as well, where some groups are quite passive and just follow the lead, others are more active. I mean, is he really convinced that forcing to have a vote will suddenly switch them from being passive to active?
Ross Greer.
It's a good point that John Mason makes, and the short answer is no. This in and of itself is not a guaranteed solution, but it's one of a range of measures that I think we're trying to put into this bill to provoke the board into being active, to participating actively in the process, to fulfilling their obligations, to scrutinising it. It doesn't guarantee anything other than that board members will, at a certain point in this process, have to make at least one active decision, i.e. they will have to actively vote on the plan. That doesn't guarantee, as John Mason indicates, we've all been in meetings with people who have either voted for or against something, and it's been quite clear that they've not read the papers before that particular meeting. I'm sure that doesn't apply to anybody here now, but we can't guarantee, we can't legislate for everyone to be a particularly effective board member, but we can legislate to build in these little mechanisms that provoke some kind of action. And I think 280, while not guaranteeing success, does at least make it a bit more likely. Amendment 35, we've touched on...
Take an intervention.
Yes.
And in regards to 280, I can hear what you're saying, what you're trying to achieve, but how can you ensure that the decisions that they do take are actually ones that are going to be effective and they're not just going to make a simple one just to tick a box and that's uncovered?
I'm grateful to intervention. So you can't guarantee that. Part of that is about the board appointment process, making sure that the right individuals are being appointed to the board, and particularly the chair. And I think we've seen the difference in recent months of having a really proactive board chair. Nothing that we can do here in legislation is going to guarantee that every individual on the board of Qualification Scotland going forward is as effective and as actively involved as we want them to be. But we can build in these mechanisms that make that a little bit more likely. And in this case, I think making sure that the corporate plan, given the importance of that document to the organisation, making sure that the corporate plan is actively considered and voted on would hopefully improve the situation. There are no guarantees here because ultimately we're talking about individual personalities and performance, which you can't legislate for. Amendment 35, we've touched on a couple of points in the past, particularly in relation to Part C that I've got in there in relation to employers. So what I'm proposing in 35 is that before the corporate plan is finalised, that Qualifications Scotland consult on it and consult a range of the key groups, as you expect, those undertaking the qualifications, the learners, those delivering them, teachers, college lecturing staff, etc. But I also think that this is the appropriate point to bring in and to engage with business, to bring in employers here. I know we've talked about it in various other settings, whether there's space on other committees for individuals representing industry, etc. I think it is important that employers who will be using the qualifications that these learners hopefully obtain are consulted on the corporate plan. So this is expanding the list of stakeholders and service users who must be consulted in preparing the corporate plan. It's not an exhaustive list, though. You can see in D that the Qualifications Scotland can consult others as required. 71, some members who are involved in the Stage 2 proceedings on the Languages Bill might recognise that. This is something, a proposal that the Law Society have made on a number of occasions in relation to public bodies to improve transparency. It should be an incredibly unlikely event that Scottish ministers reject the corporate plan of any public body. But in the event that they do, something has quite obviously gone wrong, and I would argue, and the Law Society have certainly argued a number of times in the past, that it would be in the public interest for the reasons why to be published, particularly to aid parliamentary scrutiny, which I think is relevant for this body, given the discussions that we've had about the difficulties in effective scrutiny and accountability in relation to the SQA. Thanks, Mayor.
Thank you. I call Pam Duncan-Glancy to speak to Amendment 282 and other amendments in the group. Ms Duncan-Glancy.
Thank you, Convener, and good evening to committee members, Cabinet Secretary and officials. The amendments in this group ensure, I think, the Strategic Advisory Council's role, the amendment in my name, ensures their role isn't just consultative but also visible by requiring Qualifications Scotland to show in its corporate plan how it works with the Council and responds to its advice. Embedding this in the corporate plan strengthens, I think, the transparency and reinforces the Council's influence in shaping the strategic direction of Qualifications Scotland. I think adds to many of the other amendments in this group in the name of Ross Greer, and by requiring transparency in how Qualifications Scotland will work with the Strategic Advisory Council, and it would respond, respond to the Council's advice by placing this within the corporate plan. I think that gives assurance, I think, to people who are looking to ensure that the Qualifications Scotland is operating differently to the way that the current body operates, and also that the people who are part of the Advisory Council, including those that my colleague Ross Greer has just set out crucially, have an opportunity to influence the corporate plan of the organisation, and that's why I think Amendment 282 in my name is important. Thank you.
Thank you. I call the Cabinet Secretary.
I'm grateful to Mr Greer and Ms Duncan-Glancy for setting out the purpose of their amendments. Amendment 71 from Mr Greer requires ministers to publish the reasons for the rejection of a corporate plan. Given the intention of increasing transparency and accountability, I am happy to support this amendment. On Mr Greer's Amendment 280, it is standard practice for the board to approve the corporate plan, and I expect this to continue in Qualifications Scotland. Given that this amendment simply places into legislation what already happens, I can also support this amendment. However, I would like to revisit the wording of this at Stage 3, as at present it only applies to the very first corporate plan rather than to any replacement one. I would therefore ask Mr Greer not to press this amendment so it can be adjusted accordingly for Stage 3. Amendment 282 from Ms Duncan-Glancy requires additional explanations within the corporate plan on the processes to be used with the Strategic Advisory Council. And subject matter like this is usually covered by non-legislative processes such as terms of reference and in standing orders, and is not something we would expect to be in a strategic document like a corporate plan. But I do recognise the interest in transparency, setting out the working relationships between Qualifications Scotland and the Council. Given this, I'm happy to support this amendment in general. It would be helpful, I think, though, to revisit for Stage 3 to address a point of detail around what the difference is between working with and consulting in the context of the Council being a consultative body. And furthermore, I would also be keen to change where this publishing requirement sits, as I do not think it sits best within the corporate plan. I would ask the member not to press this amendment and would work with me on adjusting it to sit elsewhere in the bill for Stage 3. Amendment 35 from Mr Greer calls for an additional consultation with specified stakeholders with the aim of ensuring the plan is aligned with the economic, environmental and social priorities of ministers. Consultation and engagement on these matters is something that I would expect to be continuous and ongoing and not just restricted to the creation of a corporate plan. Qualifications Scotland will also have a number of forums that will feed into the development of a corporate plan, including the new interest committees and the Strategic Advisory Council. with the Council being optimally placed to provide wider perspectives on these matters. And members will recall that I supported Mr Greer's related Amendment 6 in Group 10. This requires Qualifications Scotland to align with Ministers' economic, environmental and social priorities, and while I believe this overarching provision in Group 10 is quite effective at capturing the range of considerations that the organisation requires to have in mind, I recognise the value of Amendment 35 and therefore I am happy to support this.
Thank you. I call on Ross Greer to press or withdraw Amendment 280 and wind up the debate. Mr Greer.
Thank you, Convener. I'm grateful to the Cabinet Secretary for indications of support. Clearly, the drafting issue with 280 will need to be addressed. The intention here is obviously not for it to simply apply to the first corporate plan, but to all corporate plans in perpetuity. So given that and the Cabinet Secretary's indication of support for the principle, I'm happy not to press 280. I will proceed to vote once we come to 35 and 71, though.
To withdraw Amendment 280. Does any member object? No member objects, so Amendment 280 is withdrawn. I call Amendment 281 in the name of Katie Clark, already debated, with Amendment 224. Pam Duncan-Glancy to move or not move?
Not moved.
I call Amendment 282 in the name of Pam Duncan-Glancy, already debated, with Amendment 280. Pam Duncan-Glancy to move or not move?
On the basis of the Cabinet Secretary suggesting we work together at stage 3, I won't move it.
I call Amendment 132 in the name of Willie Rennie, already debated, with Amendment 115. Willie Rennie to move or not move?
Not moved.
I call Amendment 35 in the name of Ross Greer, already debated, with Amendment 280. Ross Greer to move or not move? The question is that Amendment 35 be agreed to. Are we all agreed?
Yes.
We are agreed. I call Amendment 71 in the name of Ross Greer, already debated, with Amendment 280. Ross Greer to move or not move?
Move.
The question is that Amendment 71 be agreed to. Are we all agreed?
Yes.
We are agreed. The question is that Section 14 be agreed to. Are we all agreed?
Yes.
We are agreed. I call Amendment 36 in the name of Ross Greer, grouped with Amendments 283, 284 and 37. I point out that if Amendment 133 in the group accreditation function is agreed to, I cannot call Amendment 37 due to preemption. Ross Greer to move Amendment 36 and speak to all amendments in the group. Mr Greer.
Thank you, Convener. Again, the amendments I put forward in this group are about increasing transparency and also confidence that Qualifications Scotland are engaging with the advice that they receive. So in the case of my 36 and 37, Pam Duncan-Glancy's 283 and 284 do essentially the same thing. Mine for the interest committees, Ms Duncan-Glancy's for the advisory committee. There is a requirement on Qualifications Scotland for them to publish the advice that they receive and the response that they have made to it. So this is about just trying to increase transparency here. It would give those involved in the interest committees, the advisory committee, confidence, more confidence, I would suggest, that their advice is being taken seriously, even in the occasions where it's not necessarily taken on board. But I think it's critical for those in the system more widely, for learners and practitioners, to actually see the advice and how the body is responding to it. One of the criticisms that's been made of the SQA is that they don't take on board the advice that is given to them by those with direct knowledge of how to deliver these qualifications or who have experience of undertaking them. So increasing the transparency around this, I think, would result in greater buy-in and trust across the system.
Thank you. I call Pam Duncan-Glancy to speak to Amendment 283 and other amendments in the group. Ms Duncan-Glancy.
Thank you, Convener. And just to say that I support the amendments outlined by my colleague Ross Greer. The amendments in this group, I think, strengthen accountability by requiring Qualifications Scotland to publicly report not only to the advice it receives from the Strategic Advisory Council, but how it responds to it. Including this in the annual report, I think, reinforces the Council's role as a meaningful check on Qualifications Scotland's work and ensures stakeholders can see how their input shapes decision-making. Amendment 284 in my name requires any advice by the Strategic Advisory Council and Qualifications Scotland response to be included in the annual report, and Amendment 283 is a consequential amendment to enable Amendment 284.
Thank you. Cabinet Secretary.
Thank Mr Greer and Ms Duncan-Glancy for explaining the purposes of these amendments. Mr Greer's amendments 36 and 37 together call for the annual report of Qualifications Scotland to include a summary of advice offered by its committees and any response given by Qualifications Scotland. And I support the principles and their ability to ensure greater transparency. However, I would like to work with Mr Greer to refine them. I think this may sit better as a separate requirement in the bill rather than one attached to the annual report, as this will ensure the possibility of more routine publications of this kind rather than it being embedded within one annual corporate governance document. If Mr Greer would like to work with me on this, then I ask him to not to press both of these amendments and we can adjust this for stage 3. Ms Duncan Glancy's Amendment 283 and 284 make an addition to the reporting requirements to include any advice provided by the Strategic Advisory Council and the response provided by Qualifications Scotland. And I support this objective, and it is our intention to include a provision to this effect within the regulations that establish the Council. However, for similar reasons to Mr Greer's amendments, I do not think the best place to publish this advice and Qualifications Scotland's response is in the annual report, and I'd be keen to consider this as a separate requirement. My preference would be to make this type of provision in the regulations that establish the Council, which Section 9 of the Bill already enables, though I understand the desire to prescribe this in the Bill. If Ms Duncan Glancy is not assured then we will deal with this in the regulations, then I would like to work with her on this amendment for Stage 3. Yes, I will do.
Pam Duncan Glancy.
Thank you for taking the intervention, Cabinet Secretary. Can Cabinet Secretary set out whether that would be through the negative or affirmative procedure?
Cabinet Secretary.
The negative procedure.
Okay. Thank you.
And you've concluded? Yep. I call on Ross Greer to wind up and press or withdraw Amendment 36. Mr Greer.
Thank you, Convener, and thanks to the Cabinet Secretary for her response. I like the implication in it that I was being too moderate in my proposal and the Cabinet Secretary actually wants to go much further. And I would absolutely agree with her more radical approach that we should have publication of the advice received and the response to it throughout the year on a more regular basis rather than just in the annual report. So on that basis, I'm happy not to press 36 and when we come to 37.
Thank you. Ross Greer seeks to withdraw Amendment 36. Does any member object? No member objects. Therefore, Amendment 36 is withdrawn. I call Amendment 283 in the name of Pam Duncan Glancy, already debated with Amendment 36. Pam Duncan Glancy, to move or not move?
Not moved.
I call Amendment 284 in the name of Pam Duncan Glancy, already debated with Amendment 36. Pam Duncan Glancy, to move or not move?
Not moved.
I call Amendment 285 in the name of Pam Duncan Glancy, already debated with Amendment 255. Pam Duncan Glancy, to move or not move?
Moved.
The question is that Amendment 285 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will be a division. Those in favour of Amendment 285? Okay. And those against Amendment 285? Thank you. The result of the vote on Amendment 285 is yes 5, no 5. As the outcome of the division is tied on Amendment 285, I will now use my casting vote as convener in order for the committee to reach a decision. I vote in favour of the amendment. Therefore, the committee agrees to Amendment 285. I call Amendment 133 in the name of Willie Rennie, already debated with Amendment 115. I remind members that if Amendment 133 is agreed to, I cannot call Amendment 37 due to a preemption. Willie Rennie, to move or not move?
Not moved.
I call Amendment 37 in the name of Ross Greer, already debated with Amendment 36. Ross Greer, to move or not move?
Not move.
The question is that Section 15 be agreed to. Are we all agreed?
Yes.
We are agreed. The question is that Sections 16 to 18 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 134 in the name of Willie Rennie, already debated with Amendment 115. I remind members that if Amendment 134 is agreed to, I cannot call Amendment 135 due to a preemption. Willie Rennie, to move or not move?
Not moved.
I call Amendment... it is Section 19. The question is that Section 19 be agreed to. Are we all agreed? We are agreed. I call Amendment 135 in the name of Willie Rennie, already debated with Amendment 115. Willie Rennie, to move or not move?
Not moved.
I call Amendment 136 in the name of Willie Rennie, already debated with Amendment 115. Willie Rennie, to move or not move?
Not moved.
I call Amendment 137 in the name of Willie Rennie, already debated with Amendment 115. I remind members that if Amendment 137 is agreed to, I cannot call Amendment 138 due to a preemption. Willie Rennie, to move or not move?
Not moved.
The question is that Section 20 be agreed to. Are we all agreed? We are agreed. I call Amendment 138 in the name of Willie Rennie, already debated with Amendment 115. Willie Rennie, to move or not move?
Not moved.
I call Amendment 139 in the name of Willie Rennie, already debated with Amendment 115. Willie Rennie, to move or not move?
Not moved.
The question is that Section 21 be agreed to. Are we all agreed? Yes. We are agreed. The question is that Sections 22 to 24 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 72 in the name of the Cabinet Secretary, grouped with Amendments 286, 17, 94, 22, 108 and 23. Cabinet Secretary to move Amendment 72 and speak to all amendments in the group. Cabinet Secretary.
Convener, I have proposed Amendments 72, 94 and 108, which together ensure that Qualifications Scotland and the Chief Inspector, when publishing documents, give consideration to users of British Sign Language. Amendment 108 sets out the definitions to be used when referring to BSL users and BSL education, and these were written in close consultation with the National Deaf Children's Society. And I would encourage members to support these amendments. Ms Duncan Glancy's Amendment 286 adds 2 groups to the Persons Qualifications Scotland must give consideration to when publishing documents. The first group, users of BSL, is covered by my Amendment 72, which I have just proposed. My Amendment 72 is accompanied by Amendment 108 to clarify the meaning of BSL by referring to the definition of British Sign Language, the British Sign Language Scotland Act 2015, which includes both the visual and tactile forms of BSL. As my amendment includes essential definitions, I ask the member not to press her amendment and support my amendments instead. The second element added by Ms Duncan Glancy's amendment is a requirement for consideration to be given to the needs of persons with protected characteristics under the Equality Act 2010. This does not quite make sense in this context. Protected characteristics include things like being married or in a civil partnership, and it is not clear to me how documents would or could be communicated in a way that best meets the needs of those with a spouse or civil partner. The protected characteristics which I think are most relevant here are disability and age. On that, the bill already makes specific reference to communicating in a way that meets the needs of those with additional support needs and the needs of children and young people. Yes, I will do.
I thank the Cabinet Secretary for taking the intervention, and I'm supportive of the inclusion of British Sign Language users, which is why I've included it in my amendment. But the same argument could be made because many of those users could be considered under the Equality Act, but still it's important to specifically, I think, bring out that particular definition in the bill. But the definitions that my the second part of my amendment are specifically about groups that aren't identified in the bill, so about inclusive communication for in particular disabled people. It could also be about communication in other languages as well. And so I'd ask the Cabinet Secretary to reflect on that point.
Yeah. Okay. So to the member's point, I want to come on to talk about the impact of the Equality Act, the way in which protected characteristics amendment would interact, I think, with the legislation is going to be quite challenging. I gave the example, for example, of a spouse or civil partner, for example, somebody who's married, and how you communicate with those groups. It's quite difficult to provide that differentiation, but the Equality Act 2010 will, of course, apply to Qualifications Scotland, and that includes the general and specific public sector equality duties, and on that basis, I'm not able to support this amendment. Mr Greer's amendments 17, 22 and 23 call for the consideration of users of Scots language within Qualifications Scotland and by the Chief Inspector when publishing documents. These align with the objectives of the Scottish Languages Bill, and I'm happy to support these. I move Amendment 72, Convener.
Thank you. I call Pam Duncan Glancy to speak to Amendment 286 and other amendments in the group. Pam Duncan Glancy.
Thank you, Convener. The amendment in my name in this group, Amendment 286, is to ensure that accessibility is built in to the foundation of Qualifications Scotland's work, not added as an afterthought. And by requiring Qualifications Scotland to have regard to the needs of BSL users and those with protected characteristics, I think we're strengthening inclusion and ensuring that every learner can access vital information in a way that works for them. And I have to say, some of the rationale set out just now by the Cabinet Secretary I find difficult to see as much more than a bit of a red herring, actually, about the groups in particular that the Cabinet Secretary is picking out of the protected characteristics groups. And if the Cabinet Secretary would like to intervene, I'd be happy to hear it.
Well, thank you, Convener, if the member would take an intervention. So protected characteristics are age, disability, gender, reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. So these are areas where people can face discrimination in matters such as their employment. And so it's right that they are protected. But they are not all areas which translate into having particular communication needs, which I think is the purpose of the member's amendment in relation to the format of things such as annual reports. That is why the Public Sector Duty and the Equality Act are more preferable in terms of their catch-all, to the member's point. And to the point I think she is trying to capture in her amendment as drafted, we are not of the view that the protected characteristics approach will capture that, the essence of what I think she's driving at.
Pam Duncan-Glancy.
I thank the Cabinet Secretary for that clarification. I think that it's more of a catch-all to make sure that we get all the people that need to be covered by the sorts of communication that's required. So I'm not sure I agree with the Cabinet Secretary's rationale, but I do understand it, and I do, of course, know the groups that are protected in the Equality Act. But I welcome the discussion on it. I'd also like to make the point about the definitions, and I don't see how the definitions that the Cabinet Secretary has set out would actually not still be useful if my amendment were to pass. So I don't see these as being mutually exclusive. I would intend to vote both for mine if it was pressed, which I'm minded, and for the Cabinet Secretary's definition, given that it could be useful to set out BSL. I don't think, as drafted, that setting out that definition would be problematic for my amendment. I think there are other amendments in this group, including from Ross Greer, Amendment 17 and 23. I think at this moment in time, I think preempts the conclusion of the Gaelic Bill by giving Scots language the equal footing. And so at this time, I wonder if it's appropriate in this particular amendment, set of amendments to do that. But on the other aspects of this, including BSL and including those with protected characteristics, with the specific aim of making sure that communication was inclusive and inclusive for all, I would urge members to consider Amendment 286.
Thank you. I call Ross Greer to speak to Amendment 17 and other amendments in the group. Mr Greer.
Thank you, Convener. Just directly responding to Pam Duncan-Glancy's point around preempting the languages bill, I think it is worth noting that the Scottish Government has already accepted in principle the proposals that both Ms Duncan-Glancy and myself put forward at stage 2 of that bill in relation to the SQA and Education Scotland and the use of Gaelic. But the significance of the Scottish Languages Bill is that for the first time in law it also recognises the Scots language. The point around sequencing, I think, is a fair one, but the challenge here is, so far as I'm aware, and other members can intervene to correct me, no date has been set yet for stage 3 of the Languages Bill itself. So there's a challenge of, if we don't do this now, potentially missing the opportunity to do so. But given the stage 1 and the outcomes of course, stage 1 itself, but the stage 2 debates on the Languages Bill, I think it's quite clear where the consensus, or at least majority opinion, is in Parliament. And it's worth saying on my amendments in relation to the Scots language. 23, defining it, is taking the definition that was agreed at stage 2 for the Languages Bill. And in terms of how that is applied, all these amendments would do is make Qualification Scotland and the Inspectorate ask themselves whether they are communicating in a way that is appropriate for users of the Scots language. So this would not compel them to, for example, produce every corporate plan, annual report, exam paper, etc., in Scots as well as English. That would be disproportionate, but it is a requirement on them to consider these questions of accessibility to users of the Scots language, which I think is appropriate, given, according to the last census, it was something in the region of 2.5 million people out of a population of 5.5 million in Scotland. Thank you.
Thank you. I call on the Cabinet Secretary to wind up. Cabinet Secretary.
Convener, I thank Ms Duncan-Glancy and Mr Greer for outlining the purpose of their amendments. I welcome the support for the inclusion of BSL in the bill. For the reasons I've already set out, I would urge Ms Duncan-Glancy not to press her amendments but to support mine instead, and I would urge members to support Mr Greer's amendments on Scots in addition to my own ones on BSL. I would be happy to look again for stage 3 at whether there is anything more that can or should be said about disabilities, to Ms Duncan-Glancy's point, but for the reasons I've set out, I do not think it makes sense to refer here to communicating in a way that best meets the needs of persons with a protected characteristics. Convener.
Thank you. The question is that Amendment 72 be agreed to. Are we all agreed?
Yes.
We are agreed. I call Amendment 286 in the name of Pam Duncan-Glancy, already debated with Amendment 72. Pam Duncan-Glancy, to move or not move?
Not moved.
I call Amendment 17 in the name of Ross Greer, already debated with Amendment 72. Ross Greer, to move or not move? The question is that Amendment 17 be agreed to. Are we all agreed?
Yes.
We are agreed. We are not agreed. There will be a division. Those in favour of Amendment 17? Thank you. And those against Amendment 17? And those abstaining on Amendment 17? Thank you. The result of the vote on Amendment 17 is yes 9, no 0. There was one abstention. Amendment 17 is therefore agreed to. The question is that Section 25 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 73 in the name of the Cabinet Secretary, already debated with Amendment 115. Cabinet Secretary to move formally.
Formally moved.
The question is that Amendment 73 be agreed to. Are we all agreed? Yes. We are agreed. We are agreed. I call Amendment 287 in the name of Willie Rennie, already debated with Amendment 115. Willie Rennie to move or not move?
Not moved.
I call Amendment 288 in the name of Katie Clark, already debated with Amendment 224. Pam Duncan-Glancy to move or not move?
Not moved.
It's not moved. I call Amendment 289 in the name of Stephen Kerr, already debated with Amendment 299. Miles Briggs to move or not move? That's not moved. I now call Amendment 290 in the name of Stephen Kerr, grouped with Amendments 293, 294 and 296. I call on Miles Briggs to move Amendment 290 and speak to all amendments in the group. Mr Briggs.
Thank you, Convener. And I move Amendment 290 in the name of my colleague Stephen Kerr. The intention of this group is to provide coherence, clarity and accountability in curriculum design and delivery. And that strikes at the heart of why reform is not only desirable but necessary. Amendment 290 assigns two clear responsibilities to Education Scotland. One, to update and maintain the curriculum for children and young people in Scotland, and two, to support those delivering the curriculum, including teachers and practitioners, through professional development and resources. This is essential because, as the OECD's 2021 review, Scotland's Curriculum for Excellence into the Future made clear, the governance of the Curriculum for Excellence appears to be highly complex and at times lacking in clarity and coherence. In short, the system is highly cluttered. The OECD emphasised a need for clarity about the roles and responsibilities for each actor and their boundaries, especially between Education Scotland, the SQA and RAIC, and local authorities, and also between schools and local authorities and central government. That confusion, that lack of clarity is not a technical flaw, it's a structural failure, one that erodes both confidence and accountability. We cannot hold a public body to account if we cannot say with precision what it's responsible for. Clarity must... I will do, yes.
I thank the member for giving way, except it's not his personal amendment. The fact that Education Scotland is effectively part of government, does that not make a bit of a difference here? Because really, government's responsible for everything, isn't it?
Partly agree with that. I think crucially what this amendment does is places a duty on Education Scotland to involve teachers in shaping that curriculum. So I don't think necessarily that will be impacted by ministers' direction to that organisation. They're the end users and they should be at the heart of it in terms of young people. And so I do think this amendment is important in providing that opportunity and decluttering, as we mentioned, across the education establishments.
Yes. Yeah. I'm grateful and also recognising that he's moving an amendment on behalf of that.
Like a challenge.
I understand entirely the principle behind this, but my concern is how narrow the drafting is. So I'm thinking here about the exclusion of adult learners and college lecturers. Education Scotland serves more than just teachers and the children and young people in their schools, but if we were to pass this amendment, that would, I think, quite dramatically actually narrow that and leave some ambiguity over where the place of those adult learners who are undertaking a qualification associated with the Curriculum for Excellence sit, and of course the college lecturers who are delivering it, whether to adult learners or indeed the children and young people who can be receiving their education through a college setting.
Miles Briggs.
Yeah. I think that's a good point, and I think looking at the other amendments in this group in Pam Duncan-Glancy's name, that proposes the creation of a new agency, Curriculum Scotland, to do this work. I think what my colleague Stephen Kerr has been trying to do is actually improve and look towards the future role of Education Scotland in education, and actually to make that defined within part of this bill, which I think is probably an important aspect of what we've all been looking at, that organisation and wondering what will it be doing in the future and how can it be improved. But, Convener, at the root of this reform is the challenge to urgently provide that clarification. And as the OECD report rightly reminds us, governance clarity is not just administrative tidiness, it's the precondition for an effective oversight of learner-centred improvement. I therefore look forward to hearing from Pam Duncan-Glancy and the Minister and move 290 in Stephen Kerr's name.
And Glancy to speak to Amendment 293 and other amendments in the group. Ms Duncan Glancy.
Thank you, Convener. And this is, I think, we can all agree, a pretty defining moment in the work to reform Scotland's education system. And it's important that this committee and the Parliament take very, very seriously all of the decisions that we take around it. We've had much discussion throughout the amendments of this particular bill to look at how can we bring clarity and coherence to the system, to create a system that is not driven by assessment, but that is indeed driven by curriculum. And that is what this section is crucially about, and curriculum being driven, of course, by what learners and employers need in the future. My amendments in this group seek to address some of this. The current bill as it stands, I think, fails really to grasp what the OECD said, what Professor Donaldson, Professor Priestley, Professor Muir, the International Council of Education Advisors, and most importantly of all, Scotland's teachers have said, which is that this is absolutely crucial, that we have to do more to make sure that the curriculum function and the assessment function that we have in Scotland work far more suitably for learners across Scotland. And we were promised that this bill would do that sort of reform, but it has been silent, and Education Scotland only really brought in to the bill through amendment. So this is not about adding complexity, but it is in fact about removing duplication, confusion and contradiction by creating a dedicated body to lead on curriculum as called for by the Stage 1 report, but also by many of the experts, a coherent system that ensures the curriculum drives qualifications and not the other way around. I'll take the intervention.
It's just the more I've been thinking about and listening to as you were talking there, even though we've been doing this for nearly 12 hours now, one of the things I was just thinking is this not, are we not trying to just reinvent the wheel here? Because effectively Education Scotland does a lot of this anyway. So are we not just kind of thinking about the edges just to do something, to create another body that's already, Education Scotland's already doing it?
Pam Duncan Glancy.
So, as the member knows, one of the key recommendations from the Muir report was to create a new national body that looked at the curriculum function and that also could serve as the space, which the amendments in my name do, to host the accreditation function that we've discussed much of in the committee stage 2 session so far. I should say that on the basis of the discussion we had last week about what would happen to accreditation, I'm content not to press my amendments at this stage if we're all still open as cross-party groups here to discussing what the best option is at stage 3. I'm happy to give way.
John Mason.
I thank the member for giving way. I mean, she's referred to various recommendations, including by the OECD, but I think one of the OECD's comments was that we already have a very cluttered landscape. And she probably knows exactly what I'm going to say, but I'll say it anyway. We have in Scotland a huge number of public bodies compared to other places. We are a relatively small country. We should be able to do things more simply. Every time we create another body, it takes resources away from the front line, inevitably. And would she not accept that the last thing we need in this space, as in other spaces, is yet another public body?
Pam Duncan Glancy.
I thank the member for taking that intervention, and I'm not sure I do, but I hope that that isn't an indication that the stage 3 discussions we all agreed to last week are now closed off from the government, and I see the Cabinet Secretary. Yes.
I do not speak for the government.
Just before anyone else said that, Mr Mason, but back to Mr Duncan Glancy.
I thank you for the intervention, and the point is well made. Thank you. I also did note, though, that I think I did see agreement from the Cabinet Secretary that stage 3 discussions are still on the table, and so I think that is really important, because what I've tried to do with this amendment was recognise that if we're reforming this the education system, we cannot continue to do reform after reform after reform and it be in a perpetual cycle of reforms. We have to get it right this time. And so what I tried to do was create the body or the space in this legislation for a body that could do what the the recommendations of all of these reports suggested, which was to reform the curriculum function, but also to separate the accreditation function. I've tried to do this by proposing this as a mechanism through which we could do it. I still think the bill was completely silent on some of the curriculum functions. I think there could have been more done in the bill on Education Scotland. I've obviously got amendments on that in my name, and there are in other people's names as well. But I didn't want to miss the opportunity in this bill for us to do this, to put at the heart of what we're doing for education in Scotland, the curriculum, being driven by learners, being driven by what's happening on the front line and in schools, rather than assessment. I think that the amendments I tried to put forward and I'm still speaking to, of course, that could do that. I'm not going to press them, as I agreed last week, on the basis that we'll continue to have this discussion at stage 3. Yes.
Ross Greer.
Thank you, Convener. And I'm glad that the member has brought these amendments forward. And I do thoroughly enjoy stretching the scope of a bill to the greatest extent possible, as anybody tracking the housing bill will have noticed. And I think this is a useful debate, because I agree that Education Scotland underperforms and needs to be dramatically improved, and there's a legitimate debate to have about its status as an executive agency. I'm just wondering, though, given that it seems to be implicit, but I'm not entirely clear, the creation of Curriculum Scotland would obviously then take a number of the responsibilities that are currently those of Education Scotland. Would it be the member's intention then that Education Scotland staff transfer over to Curriculum Scotland? And if so, would that be two-pay transfer? What kind of consultation would she envisage with unions? And subsequent to that, I know, particularly given that she's quite rightly posed this question to the government a number of times around regulation making powers, as currently drafted, and I take that the amendments are not being moved, it doesn't specify that the affirmative procedure would have to be used here. I think given that this is a really dramatic change, apart from anything else, this would see large numbers of Scottish Government staff be moved into another body, have their terms of employment changed. Would she agree that if we were ever to go about something like that, there would need to be a very high level of parliamentary scrutiny, and if we were to agree to it, we shouldn't agree to then essentially write ministers a blank cheque to decide on how to go about that themselves without subsequent parliamentary scrutiny?
Pam Duncan-Glancy.
I thank the member for that intervention. And then on the point of parliamentary scrutiny, I think the affirmative approach would be appropriate, and I agree that there would need to be parliamentary scrutiny on that. One of the reasons why the regulation aspect was written into the amendment was because I recognised the way in which I'm trying to do this is through a stage 2 of a piece of legislation, which is not ideal, really, and I think I've made this quite clear. I would have preferred that this had been set out from the government by taking into consideration all of the independent reviews as recommendations. I'll take the intervention.
Thank the member for taking the intervention. I'm not sure how she intends to vote in terms of my colleague Stephen Kerr's 290. But that gives Education Scotland that formal responsibility, which I think is basically what her amendments would do to a new organisation. The Minister is about to comment on this, but currently we have Education Scotland, we have Government Department, we have Glasgow University doing work on that. Is there a real opportunity as part of this bill is to just bring that into one single organisation without costing the taxpayer any more? That could and probably should be Education Scotland.
Pam Duncan-Glancy.
I thank the member for that intervention. I think this is getting to the heart of what we probably have all agreed last week that needs to be considered in terms of what we do with the accreditation function. I fundamentally believe that we can't continue to do this beyond the legislation. If we don't get this legislation right, then I think we will have failed a group of young people, because we'll have to start again. I wish the bill had included some of this in the first place. I think I've made that quite clear, both in our stage 1 speech and also in the amendments I've posed so far, but it doesn't. On the basis of the discussion we had last week, in that at stage 3 we're looking to see what the options for accreditation could look like. I'm still hopeful that we spoke about SCQF, we spoke about the Inspectorate at some point, we've spoken about Education Scotland, and we've spoken about a new body which I've called, for the purposes of these amendments, Curriculum Scotland. On that basis, I wouldn't intend to support the amendment in Stephen Kerr's name at this stage if he pressed it. Not necessarily because I don't agree with the specific detail in it, but because if we're going to do something at stage 3 that looks at one of those various options, it would be neater to do all of it at that point. So on that basis, I probably wouldn't support it at this point. I'd encourage him potentially not to move it.
Thank you. Cabinet Secretary.
Convener, I thank Mr Briggs and Ms Duncan Glancy for explaining the thinking behind their amendments and for, I think, what's been some really thoughtful contributions from committee members. Overall, I'm pleased that we collectively agree that Scotland needs a national body with a clear focus on the curriculum to drive improvement and support implementation. I would argue we already have that. But that is why I announced to Parliament last June, via a government-initiated question, that the work of Education Scotland would be refocused, ensuring its primary focus is on leading curriculum review and improvement. And as members will know, the curriculum improvement cycle is now well underway, and Education Scotland is successfully leading that work through engagement with teachers and young people. Now, when considering these amendments, the principle of legislating only when necessary has been at the forefront of my mind, as has the intended purpose of this bill, which is to establish Qualifications Scotland and the Office of HM Chief Inspector of Education. And I do ask members to keep those points in their minds as we consider this group. So turning to Amendments 290, while I understand Mr Briggs or Mr Kerr's rationale for setting out Education Scotland's functions in legislation, I believe that the same result can be achieved without the need for legislation. And actually, that cluttered landscape that Mr Briggs spoke to, I believe, is not going to be aided by creating a new national body. I do recognise members' concerns that the role of Education Scotland and its relationship to other national bodies and the sector more broadly needs to be clearer, and I agree with that sentiment wholeheartedly. It needs to be clear to local authorities, to teachers, to practitioners, what services Education Scotland offers, when and how to access those services, and there must be confidence in the quality of those services. I think following the separation of the inspectorate, hopefully following the successful passage of the legislation, I should say, we will need to continue to work with Education Scotland to define its role and relationship with the system and to clearly communicate that role to teachers, practitioners, children and young people. But I do think more broadly, for teachers who have been working in Scotland for a number of years, they will be particularly au fait with As Was Learning Teaching Scotland, which existed previously. And that support mechanism to the curriculum is well understood by many teachers across the country at the current time. Education Scotland, as I mentioned, has a key role in relation to curriculum review and improvement, and that includes, as I said, the curriculum improvement cycle and supporting local authorities. But they also do that around inclusion, behaviour, additional support needs and on closing the attainment gap. It is also important that we make best use of Education Scotland's professional expertise across priorities other than curriculum. So I've just mentioned some of those priorities. But another that I'm sure Mr Briggs and if Mr Kerr were here will be familiar with is developing leadership skills. This is a point that Mr Kerr has been pretty consistent in making, I think, both last week and today. Education Scotland will build on its success in that area, creating leadership capacity across the system. And with those points in mind, I am concerned that the amendment as drafted narrows Education Scotland's focus too much. Building on that primary focus of the curriculum, Education Scotland has much to add across other national priority areas that impact our teachers and young people, and I wouldn't want that to be curtailed or unnecessarily to stop. Mr Kerr's amendment does not take account of other national bodies and services that also have a key role to play in delivering aspects of Scotland's curriculum. I'm particularly mindful, for example, of Skills Development Scotland, and that includes our career service and developing the young workforce. And in addition, Education Scotland is an executive agency of Scottish ministers. As such, statutory functions should not be conferred on such agencies as they do not have their own separate legal personality, as I think the committee has heard today, from that of Scottish ministers. So in legal terms, there is, strictly speaking, nothing on which this duty would operate. For these reasons, I cannot support Mr Kerr's amendment. However, I note the committee's interest in the role of Education Scotland, and I would be happy to engage with members through the reform process out with this bill. Education Scotland's functions and governance arrangements will continue to be published, as they are now, to ensure that there is that transparency and clarity for the system. Now, Amendments 293, 294 and 296 from Ms Duncan Glancy would establish, as we have heard, a new body called Curriculum Scotland, set out its functions and place requirements on it to prepare and publish an annual report. And while I appreciate the intention behind these amendments, and again welcome the cross-party agreement that Scotland needs that national body that is clearly focused on the curriculum, I cannot support these amendments, and indeed, as I have previously stated, I would argue this body already exists. As members are aware, though, and as I think we've discussed, Scotland's public services are under significant fiscal pressure at the current time, and I don't believe that establishing a brand new curriculum body, in addition to Education Scotland, meets the principles of public sector reform on driving efficiency or effectiveness. It would also run contrary to the Government's commitment to creating no new small standalone public bodies, and I hope the committee members share that same view, that creating brand new public bodies via amendments to legislation should not be done first without considering the necessary policy, legal, financial and delivery implications. Yes, I will.
Notwithstanding the point that, again, I think this is a discussion we'll all return to at stage 3, can I ask the Cabinet Secretary to set out how would the Government therefore implement the suggestions in the Muir Review to create a national body on the curriculum, if it is not to do this?
Cabinet Secretary.
Well, I would argue that Education Scotland fulfils much of the recommendations that were contained within the Muir Review, and certainly my refocusing of the organisation last year has helped to drive some of that. And if we go back to the wording within the Muir Review, the Muir report recommended a National Education Agency, an executive agency, not an NDPB. So there is no need for legislation, arguably, in this space. And I think this was the point I was trying to make in my opening response to the committee. Now, more broadly, as I noted in my response to Mr Kerr's amendment previously, while curriculum review and improvement is still going to be the primary focus of Education Scotland, the remit of our National Education Agency needs to extend further than just curriculum. So Professor Ken Muir noted that need to simplify the complex landscape in Scotland, as Mr Briggs alluded to. And I think that inserting that new education body into this landscape would add an unnecessary layer of complexity in the system. Refocusing the work of Education Scotland achieves the overall aims of Ms Duncan Glancy's amendments. It ensures we have a national body that is focused on curriculum and informed by teachers, children and young people without the need for a new standalone body. On that basis, I cannot support these amendments. Convener.
Thank you. I call Miles Briggs to wind up and press or withdraw Amendment 290. Mr Briggs.
Thank you, Convener. I think what's clear is there is a cross-party discussion today in relation to how this can be formalised and for formal responsibility for maintaining the curriculum to be placed. I haven't heard from the Cabinet Secretary that that's a conversation she's willing to take away from these amendments, but beyond looking at the future of Education Scotland. But I think for members, even as part of this bill, that is something we want to see. So if she's willing to take forward that conversation with members across this chamber who want to have that, I think it would be useful, and potentially at stage 3 a workable amendment could be in there to actually direct or declutter, and I think that's where members are trying to take the government on that journey.
Cabinet Secretary.
Intervention. I'm happy to have those discussions, and I take Ms Duncan Glancy's points in particular in relation to the role of her proposals here and accreditation, which I think is a live topic that we will come back to. So I'm happy to have those discussions with members to give Mr Briggs that reassurance. Convener.
Miles Briggs. Thank you very much. Miles Briggs seeks to withdraw Amendment 290. Does any member object? No member has objected, so Amendment 290 is withdrawn. I call Amendment 291 in the name of Pam Duncan Glancy, already debated, with Amendment 115. Pam Duncan Glancy to move or not move?
Not moved.
I call Amendment 292 in the name of Pam Duncan Glancy, already debated, with Amendment 115. Pam Duncan Glancy to move or not move?
Not moved.
I call Amendment 293 in the name of Pam Duncan Glancy, already debated, with Amendment 290. Pam Duncan Glancy to move or not move?
Not moved.
I call Amendment 294 in the name of Pam Duncan Glancy, already debated, with Amendment 290. Pam Duncan Glancy to move or not move?
Not moved.
I call Amendment 295 in the name of Pam Duncan Glancy, already debated, with Amendment 115. Pam Duncan Glancy to move or not move?
Not moved.
And I call Amendment 296 in the name of Pam Duncan Glancy, already debated, with Amendment 290. Pam Duncan Glancy to move or not move?
Not moved.
Thank you very much. We now come to Amendment 297 in my name, grouped with Amendments 298, 299, 300 and 301. I will move Amendment 297 and speak to all amendments in the group. First of all, can I thank the Cabinet Secretary and her officials for their time on Monday to discuss these amendments. There's been a number of references to them, and they have so far been positive, which has certainly encouraged me throughout the proceedings so far. And there's no doubt that my motivation behind this was last year's higher history exam, and we will come on to that in a moment. However, in preparation for a number of the sessions we had about last year's higher history exam, I was alerted to a petition to this Parliament back in 2013 by Ian Thau, petition PE 01484, which was calling for a number of other things, but also calling for an independent regulator to be set up to look at examinations in Scotland. And I contacted the petitioner when I was considering these amendments, and I have to say he was extremely encouraged that despite his disappointment some 12 years ago, it was still on the radar of this Parliament, and that it was going to be discussed and considered by this committee. As I say, not everything in the amendment in the petition forms part of these amendments, but at its heart, this amendment seeks to put in place an independent individual as a regulator to look at complaints about the exam process. And I make the point about the petition back in 2013 because last year's Higher History was not a one-off event. There have been other events where parents, pupils and staff have raised concerns about SQA examinations, and the SQA have looked into these themselves. Indeed, when the petition was dismissed in November 2013, it was because the Scottish Government said it was a matter for the SQA, which I agree with, but the SQA said things were working effectively and efficiently. And I think anyone that has looked at last year's Higher History exam results and the debate around it, whether you think the outcome of the review is correct or you still have questions, the way that review was, first of all, refused for some time. It took the former Chief Executive until September to even have a review, and then the findings of that review being hotly disputed. Indeed, with the SAF survey, quotes such as from teachers of history in Scotland saying that the review of the SQA into their own examination was a whitewash, and another quote saying it was the most biased and useless investigation I have ever seen a public body attempt to pass off as legitimate. Now, again, I will give way to John Mason.
I thank the member for giving way. I mean, some of what he says does seem to be a repeat of what we've heard before, that the culture of SQA has been seriously flawed. I think we're pretty well all agreed on that. And again, as I have done before, I would question, is this a structural question, or is it more a question of making sure we get the right people in place? And then secondly, based on my previous intervention, is this setting up a new body which will also require premises, staff, costs, etc., etc.? And I would have hoped that Mr Ross was in favour of simplifying the public sector landscape and cutting down the number of civil servants. And this seems to be going in the opposite direction.
Well, I thank Mr Mason for that intervention, and he will have read my letter to his committee on my own members' bill, where I am suggesting savings that the government can make by reducing the number of civil servants. But I know this point has been made, and others who serve on the Finance and Public Administrations Committee make this point. It doesn't mean simply because we add this one that we believe every other civil servant or public body and individual should remain in post. I think there can be efficiencies made, while not saying there is not a capacity in some areas where we see deficiencies for new bodies to be established with very specific remits and roles. And I make... yes, I'll give way to Ross Greer.
I'm very grateful, and it's on exactly that point around capacity. I'm wondering what consideration the convener has given to the Finance Committee's recent report on SPCB appointed bodies, and bluntly the conclusion we came to that whether it is a matter of capacity or other structural changes that need to be made, Parliament as it stands is not effectively scrutinising and holding to account the existing group of SPCB appointed bodies, which is why the Finance Committee put a motion to Parliament, agreed, I think, 3 months ago, that at this point in time there should be no more SPCB appointed bodies created until we have taken stock of the whole landscape and what needs to change there.
I thank Ross Greer for that intervention, and I spoke to my own party's SPCB representative this afternoon about this, and I accept the points that have been made. However, I was very clear that I wanted this to be made through the corporate body, because I want this role to be completely independent from Scottish Government ministers and from the new Qualifications Scotland. So actually, when the amendments were first of all drafted by the legislation team, it was on appointment by the Scottish Government ministers rather than the corporate body. I felt some of the concerns that the Cabinet Secretary had raised about the operational independence of currently the SQA from Scottish Government ministers, it was better to have a clean break and have a truly independent individual and body, and therefore the facilitation to or the facility to do that was through the corporate body and a parliamentary corporation. As I say, I don't want to go over cover the ground of the former discussions that we've had on higher history, but I do think it is worth remembering some of the comments that were made at the time. The Cabinet Secretary, in response to a question I raised in the Chamber on this issue, acknowledged, and these are the Cabinet Secretary's words, acknowledged the various concerns raised by history teachers in the SAS survey and the need to rebuild trust and confidence. And I think if we are going to rebuild trust and confidence, yes, some members of this committee believe that will come from the new individuals in their roles at the top of the SQA. I still believe they have to prove themselves in that role. They have only been in for a short period of time. I have personally not had the same positive experience with meeting with the SQA. Just today I've had my third meeting with the SQA Chief Executive Chair and Chief Examiner cancelled and will be rearranged, but it is proving difficult to have those discussions with them. And there is no doubt that teachers were deeply worried about the outcome of the SQA inquiry. Yes, with the findings, but with the way that inquiry was established and carried out. And I personally believe, and there's no proof to this, but I think had those similar or identical results been produced by an independent individual, there would have been more acceptance. People may still not have been happy with the conclusions, and I would still have been challenging some of the conclusions, but it was the lack of an independent individual looking at this, taking evidence and determining that evidence that I think caused a lot of the issues. I'll go away to Willie Rennie.
I've got just 2 quick points. Firstly, I think the new leadership of the SQA has changed, and I think we should recognise that. I've had the same issue about meeting with them, but I think it's because they want to meet in person, so to be fair to them. But secondly, I was hoping that your amendment would be rolled into the wider discussions that we agreed to last week, because it's similar along the lines of accreditation and regulation. Curriculum Scotland is another part of that discussion. Is that something that you're considering?
Well, yes, I'm considering it more following the Cabinet Secretary mentioning it earlier on today, and I'm not going to preempt what the Cabinet Secretary will say, but if that is the direction of travel from the committee, that's certainly something I would consider. Yes, I will give way to Pamela Duncan-Glancy.
I thank the member for taking the intervention and to say that in principle I'm supportive of what I think the member is trying to do, and so I'm encouraged to hear that potentially there's room and scope to do this at stage 3, because like Willie Rennie, I agree that there is potential for us to look at some of this within the question of accreditation more generally, and also within the question of what are we going to do with the structures, because although we've had much discussion around the bodies and where we might put accreditation and whether we would have a new one, I think we really do need to go into stage 3 with options available to all of us. And I think what the member has tried to do in these amendments is something that we should look to try and incorporate, but not until stage 3.
No, I agree with that, and I will certainly make a strong effort to speak to the convener about not grouping this with the accreditation amendments that we had earlier. Maybe that would have been easier if they had been included in that grouping. But on a serious point, I think this is an issue that, while we hope the problems experienced with higher history last year are behind us, there are still concerns, and there is still a great deal of ill feeling amongst teachers and some staff within the SQA and the wider education landscape. And I would also say some of the most vocal people have been retired teachers who did experience this in previous years, who were promised that things would change, the culture would change, and they saw history repeating itself. And I think to give them reassurance that we're treating this seriously, I think it's right that these amendments are brought forward and we have a full discussion. But I'll give way to Jackie Dunbar.
Thank you. Well, I'm listening intently to what you're saying, Convener. But would the body that you're suggesting only regulate qualifications for Qualifications Scotland? Or would that not make other organisations exempt from it? I know of a few organisations that make qualifications but are not in Qualifications Scotland.
Well, this amendment absolutely does only affect Qualifications Scotland. Obviously, the bill we're looking at, the Education Scotland Bill, will, if passed, establish this new body, and I felt it was right that we look at strengthening the issues within Qualifications Scotland. But I totally accept there are other qualifications that are provided across Scotland that would not be covered by this amendment. However, to get this discussion in front of this bill today, it had to be about Qualifications Scotland. But I'll give way again to Jackie Dunbar.
I just wanted to ask you, do you not think that just makes it too narrow then?
Well, I'm grateful for that intervention. I don't believe it is too narrow. I think we have a bill in front of us that does two things, and within one part of that, the formation of Qualifications Scotland, there is an opportunity to strengthen the investigation capacity for complaints. If there's an opportunity to do it on a wider level, I may look at that, but the opportunity we have as a committee is to scrutinise this bill and the new bodies, and therefore I think it is right. And the fact maybe that it is quite narrow would maybe address some of the concern from Mr Mason that it would be very expensive, and I'm hoping the fact that it is so narrow that it wouldn't be expensive. But I'll give way to George Adam.
Yeah, it was just, I'm with Willie Rennie on the idea that SQA, there has been a change, that things have moved on. And a lot of what we're discussing here is, and a lot of the amendments are kind of pushed back on because of the historical kind of position we've had with SQA. But I feel with this in particular, and I know you're trying to find a solution to a perceived issue, but I just kind of think, is it not just too much actually creating another body, another individual? You know, I know you say it will be going, is it in the amendment? Because I'm trying to check here if it's in the amendment that you're going to do it through the corporate body of the Parliament, because I couldn't see that when I was looking at it. And I've just got some concerns about how you would actually the scrutiny of the individual themselves. So independent that they're a lone wolf.
Yeah. Well, I'm grateful to George Adam for that. The wording in the amendment is a parliamentary corporation, is how it's described in the amendments. And on Mr Adams' first point about is this necessary, I think the arguments he's making now, as we've got a change in culture, a change in leadership, and things will get better or are already good enough it's not needed, were the exact same arguments that were put to Ian Thau in 2013, 12 years ago, when he was told, look, you've got an issue here, but actually we think things are efficient and effective. And then we had the issues with higher history. We've had issues with NAT5 history this year, which may have elicited a complaint to be investigated if we had this independent regulator in place. So I accept and understand the points made by George Adam, but I think those are points that would have been made quite some time ago, that if they were acted upon at that point, we may have had an independent regulator in place who would have looked independently at the higher history exam situation that we had last year. I'll go back to George Adam before I go to Ross.
Just on the point, because I've already been said during this procedure, the progress of stage one, that, you know, the education landscape's already, you know, like I think Ross used it the other day, an MGM musical and full technical are here. You know, it's massive. So the whole point I'm saying is, do you think it's right just to add another one rather than fix what we've already got? Because the whole idea is relationships. You can't really legislate for relationships and trying to make things work and go forward. So really, you know, do you think, I hear what you're saying, but I still feel this is just kind of over legislating for the sake of it.
Well, I absolutely do believe that we need to do that, because without it is the status quo, and we know the status quo, despite the changes that may be happening and will continue to happen, will continue to take place, have lost the trust of teachers and some professionals within Education Scotland. In fact, the education sector in Scotland. The Cabinet Secretary said earlier on in the debate on Amendment 232 that there was an inherent lack of trust. We all know that. You know, the Cabinet Secretary accepts that. Every single member in this committee, I believe probably in this Parliament, accepts it. And with that inherent lack of trust, I think having an individual, independent body to look at these issues would resolve some of these points. As I say, before I come to Ross Greer, an independent regulator may have come to exactly the same conclusions as the SQA's own inquiry did last year, but I think it is more likely that that would have been accepted if it had come from an independent body rather than the SQA being seen to mark their own homework. But I'll give way to Ross Greer.
For that, and I've mentioned already the concerns that I've got in relation to creating new SPCB-appointed bodies, but I very much wanted to back up the point the convener is making about this not just being about higher history, and how in response to that 2013 petition, the petitioner was told, don't worry, the culture's changing. Shortly after I was elected here in 2016, we had a massive problem with the NAT5 computing paper that year, and it was one of a very familiar experience, one that had happened before and has happened a number of times since, where the SQA repeatedly refused to engage in good faith with those who were raising concerns, right up until we were past the point where it had been raised in Parliament. They'd sent the then Deputy First Minister out to insist that nothing was wrong. In the end, they had to, as quietly as possible, acknowledge that actually that paper was seriously flawed and significantly lower the grade. I think what was really lacking in that process, the reason I ended up having to raise it in Parliament, was the swathes of computing teachers across the country who were trying to raise concerns about this with the SQA were summarily dismissed by them. And there is something missing in the structure of our qualification system in Scotland. There's somewhere missing where people, professionals involved, learners, anyone else, should be able to go to raise complaints and legitimate concerns. The issue that we've had is that the body responsible for this system has, as a default, dismissed those concerns and often engaged in quite, I would say, aggressive defensive PR exercises instead of engaging in good faith. So I very much just wanted to back up the convener's point that, yes, higher history is the acute example that we've all been very aware of recently, but there's a long pattern of this, and it often goes back to that missing piece of the structure. There's been nowhere for people to go other than those who are marking their own homework.
I'm grateful to Ross Greer for those points and the support of the points I was making. And it crystallises my view that something is required here, and I'm interested to hear the Cabinet Secretary's response and the further discussions we will have. But in my view, and a point that I put to the former Chief Executive of the SQA, if they were so sure of their own internal investigation, they should have had no fear or concern about having an independent review. And therefore, if the SQA are happy with their procedures, are happy with everything they're doing, believe it is effective and is functioning as appropriately, they should not be concerned about an independent regulator being put in place, because they will have nothing to investigate if everything is fine. So I think it is hopefully a helpful discussion for us to have. It is an area where I think there is a deficiency in the current setup, and I wouldn't like to see that replicated in a new body. We have a unique and I was going to say fairly rare, but it can't be both unique and fairly rare, but a fairly rare opportunity in passing this legislation to change education Scotland and the structures going forward, and with the new Qualification Scotland body, I think this is an ideal opportunity to debate this, which is certainly what I'm seeking to do with the amendments in my name. And with that, I will go to any other members or the Cabinet Secretary. Over to you.
Convener, I've enjoyed the discussion with members and Mr Adams' description of the lone wolf regulator. I do want to pick up on the point you made, Convener, in relation to SQA engagement, though, because it is my intention when we complete stage 2, which hopefully will be next week, to arrange a meeting, a cross-party meeting, with all interested MSPs and with the SQA to talk to the wider work in relation to accreditation and some of the options that have been discussed this week. Happy to. Yeah,
I'm grateful, and I'm also grateful to Willie Rennie for that clarification about the change. So it's not just me, not that I was worried about that, but my office just told me for the third time the meeting had been cancelled. But if they've had issues with other MSPs, while it's not great, it is understandable, and I think most MSPs would welcome that opportunity to have that face-to-face meeting with them.
Yeah, thank you, Convener. I mean, I'm not cited on the specifics. I would just observe that last Friday the exam diet began, so that may have a role to play in this. However, these amendments, obviously, as drafted, would create a new office holder, Chief Regulator of Examinations. And while I cannot support these amendments and the approach as currently set out, I am really interested to explore all of the issues that the convener has raised today in relation to his amendments, and to work with other interested parties. To the point that Mr Rennie made, I do not think you can divorce the proposals from you, convener, from our wider discussion around about accreditation. And I think that's been a common theme from members in the contribution to the discussion. So these amendments as drafted seek to add an entirely new regulatory role into the education system, whose remit is solely focused on examinations and assessment rather than on qualifications as a whole. So I want to talk to some of the challenge here before going on to talk to the opportunities, if I may, convener. I'm advised that there's no equivalent body in comparable jurisdictions. So, for example, in England and Wales, which regulates only the examinations and assessment part of qualifications. So these regulators oversee all aspects of examinations, qualifications and assessment elsewhere. But it also, and I think this is the point that Jackington Bar was making, appears that this regulatory office holder will only be responsible for regulating Qualification Scotland examinations and assessments, and not those of other awarding bodies operating in the system. Now, Ross Greer, I think, and perhaps Mr Mason, raised issues in relation to Scottish Government's commitment to creating no new small standalone public bodies. It would create a new office holder which is accountable to the Parliament's corporate body, when this Parliament has recently voted, as members know, for a moratorium on the creation of other such bodies. And I also believe, and I hope committee members share the same view, that creating brand new public bodies via amendments, as we've just discussed, should not be done without first considering that financial, policy, legal delivery implications. But While I do not believe that there is a need for such a body in the system, and I can't support the amendments as currently set out, I do very much understand the interest from the system in ensuring that our examinations and assessments for qualifications are reliable in terms of recognising attainment and achievement. And I also very much recognise calls for action to be taken to increase the level of trust that the convener rightly spoke to, and the system in the system, and how qualifications are reviewed, and how any concerns or complaints are taken into account and listened to and responded to as part of these processes. It's really... Yes, I will.
I'm grateful to the Cabinet Secretary for giving way. Does she also accept that independence is crucial here? It must be independent from Qualifications Scotland, from government, if we are to get that trust back? Or does she believe it can be part of the new body and hopefully it would just perform better?
Well, I don't want to prejudge the outcome of these cross-party talks that we are all entering into, convener. So I will leave that, and I'm happy to engage with members on the substantive point. But I hear the point that the convener has made, and others have made similar points. But Qualifications Scotland has functions in devising and reviewing qualifications already in assessments, and I think members need to be mindful of that. And there are assurances that we seek on the validity of those processes, and they would continue to play a key role. So, for example, just as the SQA has, I would expect Qualifications Scotland to have a head of standards to oversee the support to the organisation's approach to maintaining and improving standards throughout all stages of Qualifications Scotland qualifications and awarding processes. Members have also recognised that the accreditation function that we discussed last week, which delivers that oversight of the quality assurance of the assessment components within the qualification system, plays a really important part. And we've already spoken at length about that, as I have alluded to. And we've discussed the role of accreditation in the system, not just in terms of its location, but in terms of its reach and its scope. And the point I was making in response to Mr Kerr last week is that members need to be mindful that not all qualifications in Scotland are currently accredited. So when we talk about scope, we should be mindful about what that will do to the qualifications portfolio in its totality. But I do think it's clear that all of these elements in Mr Ross's amendment cannot be discussed in isolation from one another, and particularly in relation to the points Mr Rennie made. So I would like to discuss all of this in the round when we meet on accreditation in the coming weeks. For all these reasons, I cannot support these amendments in their current form. I would ask Mr Ross not to press his amendments with a view to revisiting these collective points at stage 3.
Thank you very much. Just to wind up the debate, can I thank the Cabinet Secretary for our contribution and other members? I think it was a helpful and useful debate. I think there is general acceptance that there is an issue here. How we solve that issue going forward, it will be one we can perhaps discuss on a cross-party basis going forward, and I agree it shouldn't be done in isolation. I take on board, as I did during the debate, the points made by Jackie Dunbar and the Cabinet Secretary, but also, we can only deal with what's in front of us today and the bill that we are seeking to amend at the moment. And just finally, I remember the final words to the Cabinet Secretary to me on Monday in our call was she was going to look at the art of the possible with regards to this and hopefully others. So looking at the art of the possible and the further discussions we can have, then I am not minded to push Amendment 297. Therefore, Douglas Ross seeks to withdraw Amendment 297. Does any member object? No member objects, so Amendment 297 is withdrawn. Calling Amendment 298 in my name, already debated with Amendment 297. I do not move. Calling Amendment 299 in my name, already debated with Amendment 297. I do not move. Calling Amendment 300 in my name, already debated with Amendment 297. I do not move. Calling Amendment 301 in my name, already debated with Amendment 297. I do not move. And I think that's going to be an opportunity. I think the Cabinet Secretary's officials are changing, and we will have a short recess for 10 minutes. Thank you. Welcome back. We will resume our consideration of the Education Scotland Bill Stage 2 amendments, and I call Amendment 74 in the name of Ross Greer, group with amendments as shown in the groupings. Ross Greer to move Amendment 74 and speak to all amendments in the group. Mr Greer.
Thank you, Convener. I'm sure this is the one we were all waiting for, the outbreak of consensus. I can feel it coming. The proposal behind this, would you believe it or not, is not that I am trying to declare a republic, one public body at a time. My views on the monarchy are well known. I do think it's an antiquated concept to have inspectors serving at the pleasure of His Majesty, etc. But the motivation behind this amendment is not that. It's about government efficiency. I don't believe that orders in council and appointments via the head of state, whether it's the King or whether Britain ever does become a republic and it's a president, I don't believe that that is an efficient process, particularly in relation to a body such as the Inspectorate. So you'll
take an intervention
yes.
on that point. Unsurprisingly, he will know that Conservative members are opposed to this. But would he acknowledge that actually the presence of the Crown in our institutions is a visible and stabilising expression of democratic accountability and constitutional continuity, and reminds us that this appointment may be made by ministers, but it is under the King and in the interest of the people of Scotland. The current system reflects that balance, with the appointment being made by His Majesty on the recommendation of ministers. And if these amendments were to pass, it sets a concerning precedent that the Chief Inspector of Scotland, Chief Inspector of Education in Scotland, will become the first major public office in modern Scottish history not to have the role of sovereign deliberately removed from its appointing process. So although I would urge members to reject these amendments, I also have a 20-page speech for Stephen Kerr on this issue, and as my voice is starting to go, and it's also 10 to 8, I won't read that out, but I will give him a copy or place it in Spice, and very much we will oppose these amendments.
I'm grateful for the intervention and for not making the intervention that was requested by Mr Kirk. I'm about to conclude. I mean, I would say that the principle of democratic accountability and the Crown are two somewhat alien, mutually exclusive concepts. But in practical terms here, the King, or indeed, as the point I'm making here is not about the institution of monarchy, it's about the head of state. So even if it were a president, they're not sitting flicking through the CVs of potential candidates for Chief Inspector. And indeed, given that we have nominally, and I would disagree, but nominally, we have a politically neutral and independent head of state in the King, it would of course be deeply inappropriate if they ever did intervene in the process and reject a nominee put forward to them by Scottish ministers. That would go against the constitutional settlement that we have in the modern United Kingdom, certainly the settlement that the monarchy purports to support of neutrality in these regards. But as I said, the amendment here, this set of amendments, is really about the principle of efficiency. I don't think that appointments an oversight process via the Crown, which is, just in a second, which is symbolically independent, but in practice not independent, because for it to be genuinely independent, i.e. it would include the option, the possibility of the Crown rejecting appointment proposals made by Scottish ministers, that would violate a pretty core element of our existing constitutional setup. Yes.
Miles Briggs. Can I ask the member, given this bill will be sent to the King to sign, has he taken any legal advice over this coming back and slowing up the creation of these organisations, which I don't think the Minister or anyone has wanted to see happen, but could potentially occur?
Ross Greer.
I think on exactly that point, if the King were to refuse consent for the bill on that basis, I think that would be a constitutional crisis, because we operate on the principle that our monarchy is politically independent. Now, I don't agree that that's the reality, but that is the position that the Crown has set out, that it's independent on political matters. So to veto a bill potentially on this basis, I think would be unprecedented and would cause a constitutional crisis. Much as that may be entertaining for some of my colleagues, I don't think that's a likely outcome here. The very last point I was going to make, you'll be glad to hear, Convener, is that you'll note that I'm talking about orders in council not being an effective process for appointment, etc. The reason that I've not included all of that here is a simple practical one of between us all and those lodging amendments to the Housing Bill, etc., we've put a heavy burden on Parliament's legislation team over recent weeks. So I asked for them to draft a set of amendments that would test this issue in principle. And if the committee were so minded to agree, I would, of course, bring subsequent amendments at stage 3 to lay out the alternative process to Orders in Council, which would just be the regular appointment process that is used by all other public bodies that are not Crown appointments. But at that point, Convener, I will conclude.
Thank you. Cabinet Secretary.
Convener, I cannot support this group of amendments lodged by Mr Greer, perhaps unsurprisingly. For over 150 years, the process of appointing the Sovereign's Inspectors of Education and naming them after the Sovereign has been used to underline their responsibility to evaluate and report independently without interference from ministers. I have been clear on the need to increase public confidence in the independence of the Inspectorate, and the continuation of this, something which was recommended by Professor Muir, emphasises the distinctive and historic role of inspectors in our education system. I will do.
John Mason.
I thank Minister Cabinet Secretary very much for giving way. But I mean, surely the argument that something has been done for 150 years is hardly an argument when we're trying to revamp the Scottish education system to keep it going. And I mean, would you not accept, based on what Mr Greer's already said, that it's not independent, that the Crown is only doing things that the ministers recommend?
Convener, I'm afraid I cannot agree with Mr Mason's assertions, and I am not able to support these amendments.
Okay. Ross Greer to wind up and press or withdraw Amendment 74.
I think that despite the notable absence of the 20-page speech and our much missed colleague, Mr Kerr, I think that indeed, I think the issue has been well aired, Convener, and particularly given the time. I'm happy to conclude there, and I will be pressing the first amendment in this group, but with the expectation of the result, I will not subject members to pressing every single amendment in this group to a vote once we come to them.
Okay. I'll just say the question then before we go. The question is that Amendment 74 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Okay. Those in favour of Amendment 74? And those against Amendment 74? I got a knighthood if it was going to a casting vote. So. Thank you. The result of the division on Amendment 74 is yes 2, no 8. Amendment 74 is therefore not agreed to. The question is that Section 26 be agreed to. Are we all agreed? We are agreed. I call Amendment 140 in the name of Sue Webber, grouped with amendments as shown in the groupings. I draw members' attention to the procedural information relating to the amendments in this group as set out in the groupings. Sue Webber to move Amendment 140 and speak to all amendments in the group. Ms Webber.
Thank you, Convener, and it was nice to be back this evening. There are some familiar faces, mostly in the room, a couple of new faces online. So I suppose you'll all be delighted to know that although there are 44 amendments in this grouping that I have in my name, you'll be delighted to know that it won't be an arduous task to go through these, because they're all linked and serve the same purpose: to strengthen the independence of the Chief Inspector. As you will remember, I was here when we were taking our Stage 1 evidence, and the one thing I remember hearing loud and clear is that the Education Bill, as it stood, did not go far enough in securing the independence of that role. And as the bill stands, it states in Schedule 2 that the Chief Inspector is not subject to the direction or control of a member of the Scottish Government, other than where this is explicitly set out in legislation. And ministers will ultimately retain the ability to direct that Chief Inspector to secure inspections of specific or types of educational establishments, and these broadly reflect the current powers of ministers that are contained in the Education Scotland Act 1980. But and as I said, we heard repeatedly that there was the need for the new HM, His Majesty's Chief Inspector, to be, and importantly, almost more importantly, seen to be independent. Organisations including HDS, EIS, Children's Services, East Renfrewshire Council, they all argued that consistent reference throughout the bill to the Chief Inspector carrying out inspections at the request of ministers suggested that the Chief Inspector is not independent but is an officer who acts on behalf of the government. Yes, I will, Mr Mason.
I thank the member for giving way. Would you accept that there's a difference in ministers, say, having the power to take away some responsibility of the inspector, but for the ministers to add something on surely doesn't affect the independence?
I'll go back and remind that what I stated is it's equally as important for this to be seen to be independent and reinforce that independence if we want to have that kudos and we want to really drive that reform and to give confidence back to either the inspection process, the outcomes of that process, and so the public have trust in our system. And so there are 44 amendments because time and time again that acting on behalf of the government is referred to throughout the bill. So that's many of the provisions were open to quite a lot of interpretation. But so let's, in terms of how that independence in terms of the inspectorate is to take place in practice. And I want to take an excerpt from the Stage 1 report. Thank you, it was very well drafted. Well done. Points 254 to 257, and that's from Professor Graham Donaldson. And he was the head of the Inspectorate from 2002 to 2010, when the Inspectorate was a single body before it became part of Education Scotland. And he stated that there's no more operational independence than he had, no, let me say this again. He had more operational independence than the Chief Inspector of Education would have had under the terms of the bill as it's sitting before us today. And that some provisions of the bill meant the Chief Inspector would be in a position of constantly having to negotiate what he or she does, rather than having operational freedom and being accountable for their decisions. And the Professor carried on to state that to provide an ongoing monitoring of how the system is serving young people and to provide, where necessary, sometimes difficult messages to government or to others about where policy is not working in practice or where it needs to be changed, there needs to be further independence. And he argued, had the current inspectorate felt able to deliver difficult messages, perhaps the OECD reviews would not have been needed, and amendments would therefore require to better enshrine that independence of the Chief Inspector. And that's why I have all of these in front of us this evening. And despite the Cabinet Secretary's assurances at that time in terms of the independence, I didn't feel that the bill did create that fully independent inspectorate. So that's why I have these here. My first amendment in Group 140, makes it clear that the Chief Inspector is not subject to the direction or control of any member of the Scottish Government just by removal of the caveat subject to any contrary provision in this or any enactment. And Amendment 144, 155 and 158 all remove the influence of Scottish ministers in the office of the Chief Inspector in relation to the authority to perform and carry out their function, so they can operate fully independent from ministerial interference. Amendments 163 and 164 are amendments that specifically look to change the accountability of the Chief Inspector in that he or she will report to a committee of Parliament whose remit includes matters relating to education. So as it stands now, that would be this committee. My other amendments scattered throughout this reinforce that, changing the references from Scottish ministers to Parliament Corporation. That's amendments 141, 142, 143, 153, 154, 146, 148 and 150. Or changing references from, or changing things to Chief Inspector. Amendments 152, 200, 201, 202, 203, 204, 205, and then go back 198. I should have made these in numerical order. I'm very sorry. 198, 199, 196, 197, 19192, 193 and 194, as it's required to permit the role to function fully independently and report to Parliament, or as I've stated, parliamentary corporation. Amendments 183, 184 and 185 all remove the requirement to send any reports to Scottish ministers. Instead, Amendments 186 and 182 have the effect that the Chief Inspector must report to Scottish Parliament rather than may. So in summary, my amendments all basically remove references to Scottish ministers. I've also got in the section Amendments 179 and 180, they delete the authority of Scottish ministers to determine the frequency of inspections, and 180 ensures that when preparing an inspection plan, the Chief Inspector and ministers must also involve the Parliamentary Committee. Amendment 189 removes section 46, which is the necessary improvements and referral to ministers, Scottish ministers. Again, that's self-explanatory to me, certainly with my notes in front of me, that we are removing any influence of the Scottish Government upon the office of the Chief Inspector. I think that's where I've got them all covered.
Thank you
Thank you very much.
Ms Webber, I call Willie Rennie to speak to Amendment 145 and other amendments in the group. Mr Rennie.
What we've been trying to do with the various amendments, and indeed the bill itself, is to try and strengthen the central organisations that have got a major role in the performance of education in Scotland, because the confidence in those bodies was shattered through a number of different experiences, SQA, through the pandemic, but also the inability of the Inspectorate to identify the relative decline in the performance of Scottish education. The fact that they never identified that throughout that whole period is a big question. If in order for Scottish education to function, you need central bodies that have got the confidence not just of pupils and teachers, but of the wider educational movement, including local authorities, who are major players in the performance of education, and we need a good challenge to those local authorities, which is why we need strengthened central bodies. Now, I think we've made significant progress by separating Education Scotland from the Inspectorate, so we're not marking our own homework. I think that's a good step, and I hope we're able to appoint significant people to run both of those organisations, because people believe that they are bodies of consequence in Scottish education. I think that's incredibly important. But I think what we're trying here to do is strike a balance between George Adams' lone wolf, which is the potential for making something too independent, but also making sure we've got sufficient independence to give confidence to the wider system. I think we're trying to strike those two that balance between those two priorities. And I'm mindful of what Graham Donaldson said, that he had more independence in his day than this bill is proposing now. I think that's quite significant that he said that, somebody of his stature, and that indicates that perhaps we can go further than what the bill is proposing just now. So my amendments, quite minor in some ways, but give a greater degree of independence. So they remove the power of Scottish ministers to appoint the Deputy Chief Inspector. So I'm still saying the Chief Inspector should be appointed by ministers. Unlike Sue Webber, I don't want to abolish Jenny Gilruth. I want to keep her as an important role alongside the King in the Scottish education. I think the 147 provides that the Inspectors of Education are appointed on the recommendation of the Chief Inspector. So the Deputy Chief Inspector and also the Inspectors are under the responsibility of the Chief Inspector. And then the number of inspectors and their terms and conditions is also with the Chief Inspector. Yes, certainly.
I'm grateful for the intervention. I'm just wondering on the point on terms and conditions in particular, my concern with that would be that the Scottish Government sets at least a floor on terms and conditions through its fair work policies, and quite a lot of progress has been made on those in recent years. It would seem to me that this would take the inspectors out of that process. I wonder if you could say anything to address those concerns, because I get the broad direction of travel here. I'll talk more widely about the amendments in a moment, but just specifically on terms and conditions, my worry is that it would take inspectors out of alignment with other Scottish public sector workers who benefit from the fair work policies that have been long campaigned for by trade unions in particular.
I mean, it's a very fair point, and it's a point I should have recognised before. So I think I take Ross Greer's point into consideration on that. But in terms of also the scrutiny of the intervals for inspection, and also seeks the view of the relevant committee before any directions that are issued by the Minister. So relatively minor, certainly compared with Sue Webber. I still think ministers should have a role, but I think we should pull back and give greater independence in order to give greater confidence to those public bodies, those central bodies in education. Other members are going to propose other amendments which I think also serve the same purpose of nudging it towards greater independence without achieving the lone wolf status that George Adams so clearly craves.
Thank you. I call Miles Briggs to speak to Amendment 307 in Stephen Kerr's name and other amendments in the group. Mr Briggs.
Thank you, Convener, and I move Amendment 307 in the name of my colleague Stephen Kerr and speak in support of the substantial package of amendments in this group together, which I think go to the heart of ensuring the true independence of the Chief Inspector of Education in Scotland, and support the amendments in my colleague Sue Webber's name. In total, we're considering more than 40 amendments in this group, among them Amendments 140 through to 205, which collectively seek to establish the Chief Inspector as an independent professional and impartial voice at the heart of our national education system. And let's be clear from the outset, the creation of an independent inspectorate is not a matter of bureaucratic housekeeping. It's a matter of public confidence, professional credibility and constitutional principle. If the Chief Inspectorate is indeed to play a pivotal role envisaged within the bill, they must be seen to act free from ministerial direction, immune from political pressure and answerable ultimately not to the government but to this Parliament. And I'm pleased to support the amendments which provide that the Chief Inspector in executing their functions must do so independently of Scottish ministers. Now, this Amendment 307 helpfully, I think, provides an option to the Scottish Government that they would still be able to request an inspection, which the Cabinet Secretary has raised on a number of occasions her concern around being completely independent of ministers. But there is no obligation on the Chief Inspector to comply with this request. This therefore allows, if specific concerns are raised with the Scottish Government about an establishment, then Scottish ministers could still request an inspection, but ultimately it would still be for the Chief Inspector to decide whether that inspection should indeed take place. It's vital that this amendment is included to give ministers the ability to request that inspection where they have specific concerns, and I think there's cross-party consensus that that is needed, but this does provide for that complete and wanted independence of the inspector. So I move Amendment 307 in my colleague Stephen Kerr's name.
Thank you. I call Pam Duncan-Glancy to speak to Amendment 340 and other amendments in the group. Ms Duncan-Glancy.
I thank the convener, and in the interest of time I'll be as brief as I can on this. The independence of the Chief Inspector is something that both my colleague Sue Webber and Will Rennie have both spoken to, and indeed Miles Briggs. We heard a lot of evidence in committee about this, and the evidence cited a moment ago by Sue Webber from Professor Donaldson saying that about the independence of the Chief Inspector, I think, was incredibly compelling. The amendments, I think, seek to rebalance the relationship between government and scrutiny by making the Chief Inspector accountable to the Scottish Parliament. I think is the right forum for transparency, oversight and public trust. Recent reforms to other scrutiny and oversight bodies have rightly focused on reducing direct ministerial control, but it's only right that Scotland's Education Inspectorate be treated with the same standard of democratic independence. This is not about weakening accountability, it's about placing the accountability in the right place. And ministers, I don't think, should oversee the body that scrutinises their own practice. The Chief Inspector must have the freedom to act decisively, report openly and enforce change where needed.
Sorry, can I make an intervention?
Yes.
Cabinet Secretary.
Sorry, the member talked to the Inspector scrutinising ministers' practice. It's not the job of the Chief Inspector to scrutinise ministers' practice. It's to scrutinise practice in our schools, learning and teaching in our schools. I think it's important we make that differentiation. I'm sure you can all cast judgment on ministers' practice.
Indeed, and the intention here is to recognise that there has to be the independence between the Chief Inspector and the government. And I think that's incredibly important. And as we heard in the evidence to this committee, the bill as drafted just simply doesn't do that. Amendment in my name in this group, I'll talk to specifically. Amendments 340 require that the Chief Inspector share a copy of any report requested by Scottish ministers to be presented to Parliament and ministers at the same time. I will.
Jackie Dunbar.
And I thank Pam Duncan-Glancy for taking the intervention. In regards to the Chief Inspector not being accountable for Parliament, surely we can call, as a committee, we can call them so they are accountable to Parliament in that regard.
I thank the member for that intervention, but the member will know the powers that committees have to invite witnesses and the extent and indeed the restrictions on in what circumstances you can compel witnesses to come, but also in what circumstances you can compel people to act on committee recommendations. In fact, we've had amendments to this legislation on that very point. And so I think we need to do everything we can across this bill, including in the amendments on the Chief Inspector, to give that independence as much as we can. And I think that the members, the amendments in Sue Webber's name that I've added my name to, do this. I will take an intervention.
Ross Greer.
I'm very grateful, and sorry, it's just jumping back to the point on 340 that Pam Duncan-Gans has just concluded on there. Just for clarification, so my understanding is that the Chief Inspector provides ministers with a copy of all inspections, which is multiple inspections every week. My reading of the amendment is that as a result, if 340 were to pass, every single inspection would have inspection report rather would have to be laid before Parliament. So I don't know how many it is a week, but it's multiple inspections every week, because as is current practice, they share all inspection reports with ministers. Is that the intention of the amendment, that every inspection report be laid?
Pam Duncan-Glancy.
Sorry, convener.
No.
I was jumping ahead in the interest of time. Thank you. I thank the member for the intervention. It's the intention that the reports requested by the Scottish ministers would be shared. And I take the point about the numbers involved in that, and I'm happy to reflect on what that could mean at stage 3. So I appreciate the member's contribution on that. Amendment 342 requires the Chief Inspector to share a copy of their annual report to be presented to Parliament and ministers at the same time. Amendment 345 requires the Chief Inspector to share a copy of the report on performance of the education system presented to Parliament and ministers at the same time. And finally, in my name, solely 349 requires the Chief Inspector to share a copy of any other report presented to Parliament and ministers at the same time. I say that with the context of what Ross Greer has just put to me, and I will reflect on those points at stage 3 for 349 and 340, but I think 342 and 345 are nonetheless really important. All of the amendments, I think, mean that we give an opportunity for Parliament to have scrutiny over the real scrutiny over the education system in Scotland. I recognise the important role the Chief Inspector, that the Chief Inspector of Education plays, and the importance of this role having a strong degree of independence away from government. Hence my support for a number of amendments in Sue Webber's name. I'm not going to list them all for the interest of time, but I think they do strengthen the independence of the Chief Inspector by making a number of functions accountable to Parliament rather than ministers, among other things. However, there are some aspects of the role of the Chief Inspector I think shouldn't be politicised in the way by being accountable to Parliament might make them. And as such, I can't support all of Sue Webber's amendments in this group, 146, 153, 154 and 155, relating to matters such as terms and conditions of staff employed within the Chief Inspector's office, and I think that these should continue to be determined with the approval of ministers. A number of Willie Rennie's amendments, I think, are direct alternatives to the ones that have been proposed by Sue Webber, which I support. I therefore cannot support them. And Amendment 307 in the name of Stephen Kerr. I currently think this amendment is already in the wording of the bill, and I'd be interested to hear why the additional amendment in Stephen Kerr's name is needed. I'm not convinced at this point that it is. Amendment 187 in the name of Sue Webber, relating to powers of entry and inspection in respect of a dwelling house, I don't think is an amendment. This is not an amendment I'm against at all. However, having not heard any evidence on this at the present time, I feel I will take an intervention, of course.
But yes, that was just to provide clarity around the involvement of homeschooling and of residential and boarding as well. That was why I've got that amendment in there.
I thank Sue Webber for the intervention, and I appreciate that clarification. I think at this stage, given that we didn't actually hear much evidence on the homeschooling aspect of inspection that I can immediately recall, I'd probably be inclined, if the member did press it at stage 2, to abstain, but I'm open to discussions about what that could look like potentially at stage 3. But at this point, I don't feel like I've got enough evidence to inform fully my position on that particular amendment. And then, on that, I'll close my remarks.
Thank you. Ross Greer.
Thank you, Convener. Much of my position on particularly the large group of amendments from Sue Webber is a reflection on what we discussed in relation to the Convener's amendments on a new independent regulator, and it's primarily that, as a member of the Finance Committee alongside John Mason, we considered issues related to the creation of new public bodies, particularly SPCB-appointed bodies. We produced a report for Parliament with a strong recommendation, and unusually for a committee report, we put forward a motion to Parliament that rather than asking Parliament as a whole to note our report, we asked Parliament to agree specifically to that moratorium on new SPCB-appointed office bearers. There's some specific issues that I have in relation to moving the inspectorate entirely within the purview of Parliament, though, because ultimately ministers do have a significant responsibility for the setting of education policy in Scotland. And if we're to have a wider debate around whether we are taking education policy out of the remit of ministers entirely, I would have a lot of questions about that. But the example that I've used before, I think I might have used it in the Stage 1 debate, is it's entirely legitimate for Scottish ministers to have decided on a specific element of education policy, to have instructed and expected schools to implement it, to then, after a few years, ask the Chief Inspector to conduct a thematic inspection on that. So the examples that I would use would be the government's decision of 5 or 6 years ago on LGBTQ inclusive education. I think it's entirely legitimate for the government to say that they want a thematic inspection to make sure that has been implemented. Many of the recent debates that we've had in Parliament around pupil behaviour and violence against women and girls in particular, I think it is important, particularly when Parliament holds ministers to account, quite rightly, on issues like this. I think it is appropriate for ministers to still maintain the power to instruct a thematic inspection on, for example, how schools deal with violence against women and girls, that being an issue that I do actually think requires it, because I think there's significant inconsistencies in policies there. I do want to strengthen Parliament's role and relationship with the Inspectorate, though. So my Amendment 92 that we'll come to later does that in relation to inspection plans. And I'm very open to other ways in which we can do that. And I think probably the best way to describe it is that we want, or I want, greater independence in most areas of practice for the Inspectorate, but not in its form, and not in every area of practice, as Pam Duncan-Glancy highlighted, for example, the terms and conditions of Inspectorate staff. And I would also, I think, probably share her position in relation to the points around homeschooling. Just very briefly on Willie Rennie's amendments, I'm pretty minded towards 147 in particular, although I've got some questions there about the practice of inspectors being appointed on the recommendation of the Chief Inspector when they're also being, in practice, appointed by the Chief Inspector. But I think the kind of principle behind that one is sound. Same with 160, I think adding some extra scrutiny to the regulations around the intervals for schools to be inspected is desirable. I've got quite significant concerns about 156, actually, because I can envisage situations in which ministers would want to instruct the Inspectorate to inspect a school, for example, for very specific reasons related to welfare concerns that have been raised, where the delay that would result from having to seek the approval, the input of a parliamentary committee, I don't think would be acceptable in circumstances such as that. I think there are situations in which I would welcome some kind of mechanism whereby when it's not urgent, ministers seek the input of Parliament, but I wouldn't want anything that could delay ministers instructing inspections where it's a welfare issue in particular, and I'm aware that that's been the case in the past. I welcome Amendments 342 and 345 from Pam Duncan-Glancy, but on 340 in particular, my concern, and I'd welcome if the Cabinet Secretary could clarify this, is that the situation at the moment is that, in practice, ministers request a copy of every single inspection report, and there's a number of those every single week. And the process of laying all those before Parliament would not just, I think, be an unnecessary burden on the Inspectorate, but it would place an additional burden on Parliament. The Business Bulletin would certainly get a lot larger each week. So for that reason, I don't think I could support 340, but I think 342 and 345 are quite advisable. Thank you, Convener.
Thank you. Cabinet Secretary.
Convener, I thank members of the committee for setting out the purposes of their amendments. I welcome Sue Webber back to the Education Committee, even though she is trying to abolish my existence. But broadly, this group of amendments, as we've heard, seek to curtail or remove ministerial powers across Part 2 with the aim of seeking further independence of the Office of the Chief Inspector from Government. And there are, firstly, very good overall reasons why ministers will continue to have that direct relationship with the Chief Inspector set out in the bill as introduced. And I've heard members raise contribution from Graham Donaldson, who served as the previous Chief Inspector some time ago now. But I do think it's worthwhile reminding members that Graham Donaldson, when he was Chief Inspector, and indeed our current interim Chief Inspector, had no power under legislation. Every inspection they had, or that happened under their watch, was caused by ministers because their existence was not specified in legislation. So I think members should be mindful of that difference. Ministers have a duty, as I think we've heard from Mr Greer, to endeavour to improve the education system and to take necessary enforcement action as well as regulatory powers in relation to our independent schools. So without even limited power to direct inspection, it would be extremely difficult for ministers to fulfil these duties. There have been a number of important issues around the system that ministers have used their powers to ask the Chief Inspector to investigate and report on, using a thematic inspection model. Again, I think Mr Greer made this point. So this includes things like behaviour, attendance, the national thematic on maths, which members will recall occurred on the back of the 2022 PISA results, which I will not dwell on, and in relation to local authority improvement functions, which was a point I think Mr Rennie raised quite rightly. And if members are interested, the Chief Inspector published a report on this, I think it was in February now, very, very recently, and it's a really interesting piece of work. But in the past 10 years, Scottish ministers have used the power to request that HM inspectors carry out a special inspection on 8 occasions, only twice since I took up post. And on all occasions, these focused on specific ministerial concerns brought to their attention in the first instance by HM inspectors or the Registrar of Independent Schools. Therefore, while it is anticipated this power would be used rarely, it is important that it is available. Yes, I will do.
It's just on that part you're discussing there, Cabinet Secretary. It's one of the concerns I have with this is should something go wrong and the inspector actually reports something, you know, you're in Parliament, you're accountable to the Parliament. So every one of my colleagues here can go into the chamber and demand that you do something about this. My concern about this is you could then answer any question at that point and say, well, it's not really my job anymore. So basically talk to the Chief Inspector. So is there not a case of you're watering down accountability in this stage if you go for either Mr Rennie or Ms Weber's amendments?
I think I would broadly agree with the sentiment behind Mr Adams' question, and I think it's important that it is ministers who hold the power to take that enforcement action based on information from inspection where that is necessary and proportionate. And the Inspectorate of Education is not, in my view, or should it be, about a regulator, and it would fundamentally change its character if they were to take on this enforcement role, which is not the role of the Inspectorate at the current time. So I therefore cannot agree with Amendment 155 from Sue Webber, even if that is accompanied by 307 from Mr Kerr, who I appreciate is not here, which would leave ministers without the ability, under any circumstances, to require the Chief Inspector to secure the inspection of a particular establishment, including where there were significant concerns raised. And I would similarly urge members to reject Mr Rennie's Amendment 156, which would require ministers to seek the views of this committee before requesting an inspection. Now, given the circumstances in which powers are likely to be used, for example, where there may be urgent concerns, as I think that was a point that Mr Greer was raising, it would not be appropriate to take time for this step where we have to move at pace. And I would also urge members to reject Ms Webber's Amendments 189 to 205, which removes ministers' role in relation to enforcement directions. Additionally, as already alluded to, Ms Webber's Amendment 155 would remove the requirement of the Chief Inspector to comply with a request from ministers to inspect an educational establishment. It would also, though, remove the power of the Chief Inspector to secure the inspection of an accepted establishment on request of ministers. Amendment 161 would remove the accepted establishment definition in section 31(4) of the bill. This is pretty problematic, as these amendments taken together would bring post-16 further education colleges and the higher education institutions that deliver accredited initial teacher education within the scope of the Chief Inspector's duty to secure inspection of educational establishments at such intervals and to such an extent as the Chief Inspector considers necessary. Now, under the current provisions, these accepted establishments would only be inspected on the request of ministers. Now, I support the need for robust quality assurance mechanisms to be in place for post-16 further education for ITE. However, this already exists through 2 separate oversight and regulatory mechanisms. The Scottish Funding Council, who I know have written to the committee, already have statutory duties to ensure provision is made for assessing and enhancing the quality of university provision, including ITE and post-16 further education. And in relation to ITE specifically, a second existing layer of regulation is that led by the General Teaching Council for Scotland, which is the relevant professional body, and I should refer members to my register of interest in that regard. This amendment would create a third layer, adding further duplication, additional bureaucratic requirements and extra costs to higher education institutions with no discernible benefit. So more broadly, members' amendments in this group have competing conceptions as to whether power over a range of matters should be vested in the Chief Inspector alone or whether it should be vested in the Scottish Parliament's corporate body and in this committee. On the latter, a range of amendments lodged by Ms Webber seek to place powers with the SPCB as opposed to with ministers. And Convener, I'm particularly mindful, as we have discussed, that the Finance and Public Administration Committee, which includes Mr Mason and Mr Greer, reported in September 2024 on the number of bodies supported by the SPCB, recommending the need for a moratorium on any more. The Parliament voted on accepting that recommendation, and the Convener and Ms Webber were amongst those supporting. But more than that, the committee also noted that the SPCB supported body status was not necessary to be able to demonstrate independence from government, with policing and prisons inspectorates cited as good examples of government-led bodies which act independently and produce robust recommendations. So given the model for HM Chief Inspector of Education set out in the bill as introduced broadly follows that same approach, it is not clear why the Education Inspectorate cannot be equally successful. In addition, the model as proposed in the bill would allow us to meet one of Professor Muir's key recommendations, that HM Inspectors of Education continue to be civil servants. This would not be feasible if they were to become employees of the Chief Inspector, with all the implications that brings in terms of the transfer of staff. And I would also like to reference that in its Stage 1 report, the committee noted that some members did not consider it necessary for the Chief Inspector to be accountable to the Scottish Parliament. Happy to do so.
Willie Rennie.
I understand all the arguments that she's putting forward, but I think the inspectorate within education is in a different position from the inspectorates of the police and the prisons, because we have had some we call a crisis in recent years. And although we are separating from Education Scotland, we still, I think, need to go further. Does the Minister think there is any avenue that she's examined that we could pursue to give greater independence? If she doesn't agree with any of the amendments that have been put forward, is there anything that she might consider in order to bolster that, which I think she agrees with, because she was nodding away when I was hopefully contributing earlier on, that we do need to build up the confidence of the central bodies. Is there nothing that she's looked at that we could pursue to give greater independence to build that confidence?
I'm going to come on to some of the points where I agree with Mr Rennie, but just to pick up on his point there in relation to a crisis, I think we need to be mindful of some of the challenges that exist in our education system. But to my mind, the position of the Inspectorate in that regard has not been in the same challenging position that perhaps the SQA has in recent years. And I'm not necessarily sure you can apply the same comparisons to those bodies. I think there's a strength within the Inspectorate, which will further be strengthened, of course, by the government putting those responsibilities into statute, which hasn't existed previously. I'm going to come on to talk about some of the points.
Just briefly come back on that point. I mean, some people would say, and I would agree with it, that the Inspectorate did not identify the challenge that Scotland was facing internationally with its performance in education. It did not report.
So I'm sympathetic to the points that Mr Rennie raises, and actually Mr Greer spoke to the school inspection reports that I receive every Friday from the Chief Inspector and read diligently, and there is a review he will know at the current time being led by the Interim Chief Inspector in relation to inspection reports and how those are compiled, and I hope he's engaged with the Chief Inspector on that, but I take the point he makes about identifying those challenges and giving advice and challenge to ministers, as is the responsibility of the Chief Inspector. Yes, sir.
John Mason.
I mean, it strikes me listening to Willie Rennie's intervention. Obviously, I can't intervene on him at the moment, but surely part of the answer to that is the fact that the Inspector could come before the Education Committee, and the Education Committee, through questioning and challenging and whatever, he or she would have the opportunity to demonstrate their independence just by their attitude at the committee.
Indeed, that is the case, Mr Mason. So I'm conscious of time, Convener. In its Stage 1 report, the committee asked the government to strengthen measures within the bill relating to the Inspectorate's accountability, including to Parliament. So I did listen to that, to Mr Rennie's point, and I support, subject to a slightly shorter time frame, Mr Greer's Amendment 92 in the Inspection Plan Group, requiring the Chief Inspector to lay a draft inspection plan in Parliament. This amendment gives an opportunity for Parliament to review and comment on the operations of the Chief Inspector directly to the Chief Inspector. Amendment 160 from Mr Rennie looks to add the recognition of the important role of Parliament in relation to the ability of ministers to make regulations to specify intervals at which establishments are to be inspected. In this regard, I would emphasise that any regulations are already subject to the affirmative procedure, meaning that they will not become law unless approved by this Parliament. Now, Ms Webber's Amendment 180 also seeks a role for this committee in the event that regulations are made setting the frequency for an inspection plan being reviewed. These regulations are already subject to the affirmative procedure, and I would submit that this therefore already fully involves this committee. To return, apologies, Convener, to Mr Rennie's Amendment 160, though, this amendment appears to create a special class of regulations which are subject to an excessive period of parliamentary procedure, significantly longer than that used in the super affirmative procedures for other regulations. So while the content of any regulations will of course be important, it will not be as complex as some other regulations subject to a shorter laying period. So, for example, even the creation of a register of controlling interest in land, which was incredibly detailed, was only subject to a 60-day laying period. However, while unable to support this amendment in its current form, I would be happy to work with Mr Rennie to take forward a revised amendment which fulfils his intent in a more manageable way. More broadly, Mr Rennie has lodged a range of amendments which remove powers from ministers in relation to inspection staff and vest these instead in the Chief Inspector. Now, generally speaking, these would give a great deal of largely unchecked power to an individual office holder without any obvious restrictions or safeguards. This would be concerning and likely to bring unintended consequences yet to be fully understood. So, for example, the Chief Inspector alone would be empowered to determine the number of inspections that would be employed without any apparent limit. It could also introduce an element of inconsistency into staff terms, where those could vary purely depending on who the Chief Inspector is at the time of appointment. And once again, it would be difficult, if not impossible, for such staff to continue to be civil servants, as recommended by Professor Muir. For those reasons, I would urge members not to support Mr Rennie's amendments in this area. Now, moving to Amendment 182, lodged by Ms Webber, this appears to require that every individual inspection report is laid before Parliament, as I think we have heard from other members. It is difficult to envisage that Parliament would have the capacity, as Mr Greer made the point, to do much with those individual reports on every establishment inspected, expected to be around 250 a year. I would contend that it would be better for Parliament to focus on the overall annual report on the performance of Scottish education, as has already been allowed for. And I would also emphasise that every inspection report will be published as they are today, so they will be available to the public and to MSPs from publication, and I therefore urge members not to support those amendments. However, I do have more sympathy with Ms Webber's Amendment 186, which replaces the Chief Inspector's power to lay any other report about any matter relating to the Chief Inspector's function before Parliament with a duty to do so. While this arguably removes an area of discretion for the Chief Inspector, I am happy to support this as a further recognition of the importance of Parliament being kept informed of the Chief Inspector's judgment. Now, Ms Duncan-Glancy has also lodged amendments relating to Parliament and ensuring that certain reports that the Chief Inspector produces are simultaneously provided to Parliament and Scottish ministers. And I also have sympathy with the intention here. I would therefore support Amendments 342 and 345, which relate to reports which must be laid before Parliament in the bill provisions as drafted. However, I am concerned that applying the same restriction to reports that may be laid before Parliament would have unintended consequences by reducing the number of reports laid, because they would essentially prevent reports from being laid before Parliament if they are not laid in the narrow window of time mentioned. So I would therefore urge members not to support Amendments 340 and 349, and I'd be happy to discuss further with Ms Duncan-Glancy if she has any concerns about this.
Thank you. Sue Webber to wind up and press or withdraw Amendment 140. Sue Webber.
Thank you, Convener, and thank you, Cabinet Secretary, for responding there in such detail. I do want to also thank Pam Duncan-Glancy for her support to a variety of the amendments scattered and peppered through this. But what's right, what we have all been trying to do, whether to different degrees, is to rebalance what we are hoping the role of the Chief Inspector will do in our schools and bring back confidence and trust. And we do want accountability to be in the right place. I think you did mention about some of the competing conceptions, Cabinet Secretary, and yes, although you did raise the reporting to the SPCB and the moratorium report that I intended to support, but I'll go back to some of the comments that were made earlier from the convener, if I can finish my sentence, the convener in relation to what he was discussing. Just because we've had that moratorium doesn't mean it ceases to happen. And when there is a need, and a need that we think should be there, and the education is critical to the future for so many people, I don't think it should be dismissed offhand on the back of something like that report. So I'll take the intervention now.
Jackie Dunbar.
I thank Sue Webber for taking the intervention. It was in regards to your amendments relating to the SPCB. Do you know if they've actually got capacity for this? Because I know that our own group member tells us how busy the SPCB is continually, and she's raised concerns with us regarding the capacity. I just hope she's not watching this just now. And also, would if it was given to the SPCB, would they not need to have an in-depth knowledge of what to do in order to deal with these matters, you know, to make those decisions? Because I think it would, I'm thinking aloud here, but I'm thinking it might actually dilute the responsibility if they've then got to go and take advice on what they need to call in or not call in.
I think thank you, Convener. In terms of the expertise, my amendments do say that they will report to a committee of Parliament whose remit includes matters relating to education. So in terms of having the ability to drill down and understand what that inspector is doing, that would be, I suppose, this committee. Every committee is extremely busy and pressed, hence we are sitting here at 2038. So I don't think you could say that one committee is more busy than another. And as a member of the Standards Committee, we are currently undertaking an inquiry into committee effectiveness, so perhaps that's something that can all be considered as part of that, Ms Dunbar. So I hope that answers your questions there. Can
I come back, if you don't mind?
Yes, you can.
Jackie Dunbar.
Sorry, maybe it was just my word, and I mean, you're right, we're all busy, but do they have the capacity to undertake this work?
Some may
in all the time?
Sue Webber.
Well, again, drawing reference and parallels of where we are tonight, did the Education Committee have the capacity to deal with nearly 400 amendments on an education bill that we're having to sit on a number of evening sessions? I think we need to look long and hard at the entire capacity of the Parliament and committees to deal with the amount of legislation and work that has been asked of the committees. So in terms of that, you know, what my intentions were here, you know, Audit Scotland is held up as a really good organisation that's heavily critical and well respected in terms of how it reports to the Parliament in its various inquiries. And my head was in that space, that I was looking for the Chief Inspector of Schools to have that kudos, that influence and that trust in the public, which I think has been most absent from a number of things when it relates to education in the last few years. So with that, that's where we are. And I think given the feeling and sentiment, Convener, I will not press 140.
Thank you. Sue Webber seeks to withdraw Amendment 140. Does any member object? No member objects, so Amendment 140 is withdrawn. I call Amendment 75 in the name of Ross Greer, already debated with Amendment 74. Ross Greer to move or not move?
Not move.
I call Amendment 141 in the name of Sue Webber, already debated with Amendment 140. Sue Webber to move or not move?
Not move.
I call Amendment 302 in the name of Stephen
Point of order.
Yeah, please.
Can I just ask how long you're planning to go on tonight? Because I don't think we're going to get through this by 9 o'clock.
No, it was never. Sorry, Mr. Mason. It was never my intention to get through this by 9 o'clock, but to continue till about 9 o'clock. That gives us an hour following the break we had. So I'm sorry, I did try to tell as many members, but that's what I'm aiming for, about 9 o'clock, if that suits members and the Cabinet Secretary and her officials. If there is any issue, or are we okay? So about another 20 minutes, if people are okay with that. I was calling Amendment 302. Yep, so I call Amendment 302 in the name of Stephen Kerr, group with Amendment 303. Miles Briggs to move Amendment 302 and speak to both amendments in the group. Mr Briggs.
Thank you, Convener. And I move that both Amendments 302 and 303 in the my colleague Stephen Kerr's name, which are also in concern of the appointment of the Chief Inspector of Education. The purpose of these amendments is to ensure that the appointment process for this crucial post is robust, transparent and principled. The bill, as introduced, creates a position of Chief Inspector, but it does so with minimal definition regarding who should be eligible to hold that office and how long they should serve in that role. In the role of such significance to the quality and integrity of Scotland's education system, that omission is neither trivial nor technical. So let me begin with Amendment 302. This amendment proposes that to be eligible for the appointment as Chief Inspector, an individual must be a qualified teacher and have held a senior leadership role within a school or other educational establishment. This is not an exclusive clause. It's a statement of principle, and that those who have led the scrutiny of education in Scotland should have substantial and relevant experience of the sector which they will be inspecting.
Will the member take an
Yes,
on that point?
yes. Thank you.
Briefly, I'm minded to support the intention of this amendment specifically, but can the member clarify what definition Stephen Kerr is using to define registered teacher?
So, looking at the Muir review, it repeatedly stressed the importance of reconnecting national bodies with lived experience of teachers. And in terms of that, Professor Muir himself wrote that it's essential that those who hold leadership positions in national education bodies have experience of the sectors they oversee and can demonstrate that credibility and understanding when engaging with practitioners. So the definition, I think, is open to further amendments at stage 3. It's not outlined as such as an amendment, but it's actually looking towards those leadership skills, which I think my colleague Stephen Kerr and I think the wider committee would be supportive of potentially outlining in further detail at stage 3. Yes.
I'm grateful, and I have a lot of sympathy for the principle behind this amendment. I just wanted to confirm that 302 is not going to be pressed at this stage, given it's premised on the parliamentary corporate body making the recommendation, and given that those amendments haven't been moved and we're taking that debate outside of these proceedings ahead of stage 3. Because I think this is a useful principle to debate, but what's currently there as 302 wouldn't be applicable to the system as it stands.
Sure. No, thank the member for that intervention. I'd like to hear what the Cabinet Secretary has to say before taking that decision. But in relation to 303, this amendment proposes that the Chief Inspector be appointed for a fixed and non-renewable term of 7 years. Again, this is about protecting the independence of that role. A non-renewable term removes the risk of perceived favour-seeking. It liberates that post holder to lead fearlessly and impartially. And 7 years is, I believe, a reasonable period, long enough to ensure strategic continuity and an impact to be made. Also keeps fresh leadership in mind. This approach is consistent with other public appointments in Scotland and beyond, and is a safeguard against politicisation, against entrenchment of authority and against dilution of challenge. In the committee session last week, we had a long discussion about whether 7 years was an appropriate length of time to be ahead of an organisation, and if this would have unintended consequences of forcing someone out of the role, even if they were performing highly. And I don't think that's the case. Convener, to summarise, Amendments 302 and 303 work together to professionalise and protect the role of the Chief Inspectorate, and I move both amendments in Stephen Kerr's name.
Thank you very much. Call the Cabinet Secretary.
I thank Mr Briggs on behalf of Mr Kerr for setting out the purpose of these amendments, and I believe that both of these bring forward important points, but I'm not able to support them in their current form. Now, in relation to Amendment 302, leaving to one side for the moment which entity would be appointing the Chief Inspector, I agree with the principle behind the amendment, which I take to be that the Chief Inspector should have relevant educational experience, including at a leadership level. However, I believe there are a number of issues with the amendments as currently drafted, principally that in insisting that the Chief Inspector should be or have been a registered teacher, this may unintentionally exclude excellent candidates. In particular, depending on how the idea of being registered is interpreted and whether that means registered with the General Teaching Council for Scotland, it may exclude someone from out West Scotland who has not been registered here. In relation to Amendment 303 and with regards to the appointment term being limited to a maximum of 7 years, with reappointment prohibited, even if the original appointment was for much less than 7 years, I would suggest to members that this is unnecessarily prescriptive. Now, as I flagged to Mr Kerr in the debate on Group 4 last Wednesday, where he sought similar provisions for the Chief Executive of Qualifications Scotland, the terms of Chief Executives, and in this case other HM Chief Inspectors for other inspectorates in Scotland, are generally governed by appointment contracts and governance frameworks rather than explicit legislative term limits. On removing the ability to be reappointed as Chief Inspector again, I would point out to members that this removes that flexibility which in certain circumstances may be needed to ensure the effectiveness of the office. However, I do understand the reasons behind both of these amendments, and while respectfully asking that these are not pressed, I would commit to working with Mr Kerr, or indeed Mr Briggs, ahead of Stage 3 to agree a way forward.
Very much. And Miles Briggs, to wind up and press or withdraw Amendment 302. Miles
Thank
Briggs.
you, Convener. The Cabinet Secretary will know how keen a consensus builder my colleague Stephen Kerr is. So in that frame of mind, I will not be pressing 302 and 303, and we can all look forward to working together on hopefully a workable amendment for Stage 3.
Thank you very much. Miles Briggs seeks to withdraw Amendment 302. Does any member object? No member objects. Amendment 302 is withdrawn. I call Amendment 76 in the name of Ross Greer, already debated with Amendment 74. Ross Greer, to move or not move?
Not move.
I call Amendment 303 in the name of Stephen Kerr, already debated with Amendment 302. Miles Briggs, to move or not move?
Not moved.
I call Amendment 142 in the name of Sue Webber, already debated with Amendment 140. Sue Webber, to move or not move?
Not move.
I call Amendment 143 in the name of Sue Webber, already debated with Amendment 140. Sue Webber, to move or not move?
Not move.
I call Amendment 144 in the name of Sue Webber, already debated with Amendment 140. Sue Webber, to move or not move?
Not move.
I call Amendment 77 in the name of Ross Greer, group with amendments as shown in the groupings. I point out that Amendment 311 is preempted by Amendment 158, previously debated in the group Independence of the Chief Inspector. Amendment 314 is preempted by the Amendment 162, previously debated in group Independence of the Chief Inspector. Amendment 336 is preempted by the Amendment 179, previously debated in the group Independence of the Chief Inspector. I call Ross Greer to move Amendment 77 and speak to all amendments in the group. Mr Greer.
Thank you, Convener. This is a pretty similar debate to the ones that we've had in relation to the interest committees, the Board of Qualifications Scotland, and particularly the Strategic Advisory Committee there. 77 and 91, I should say, are essentially enabling, 91 is consequential of 78, 77 expands the starting membership of the Advisory Council because of what I'm proposing in 78, though you'll note that ministers would still have the power to vary the size of the council as required. 78 is the substantive amendment I'm bringing in this group, and it seeks to bring in those who have direct experience of actually being in education establishments that are the subject of HMI, primarily schools, so therefore primarily pupils in schools and teachers, but also college lecturers and students there, and also to make sure that the voice of the staff of the inspectorate, the inspectors themselves and their support staff, is heard as part of this and is on the Advisory Council. It's because, as much as we've paid a great deal of attention to governance arrangements for other parts of the education landscape over recent years, I think it's fair to say that the inspectorate is a bit of a black box for a lot of people who are actually in our schools, in our colleges at the moment. There's a real lack of understanding about it, that there's an element of a somewhat standoffish approach, people feeling that inspections are certainly imposed upon them, that it's a very top-down process, etc. I think the Advisory Council proposals that are in the bill are very welcome. I think they can be strengthened by being a bit more specific, not in an exhaustive way, but being a bit more specific about the kinds of people that we wish to see as part of that advisory group. Just touching briefly on the other amendments, on Pam Duncan-Glancy's amendments, I would welcome if, when speaking to them, if she could just explain a little bit about the thinking there, because as far as I understand it, it replaces the word advisory with the word governing, but the council would still not actually have any governing powers over the organisation, and I'm worried about ambiguity that might be caused by that, so I'd welcome if she was able to talk about to that. 326 mirrors an amendment that I had moved in relation to the Board of Qualifications Scotland. I'd certainly be happy to support that. I don't think I'll be supporting 172 in the name of Miles Briggs. I did vote for a representative of parents and carers to be on the Qualifications Scotland Strategic Advisory Council. I'm less convinced of the need in this case, but I am open to the case that Mr Briggs will be putting forward.
Thank you very much. I call Pam Duncan-Glancy to speak to Amendment 311 and other amendments in the group. Ms Duncan-Glancy.
I thank the convener for inviting me to do it and to give me 2 seconds to get my correct notes pages up to support my contribution. Thank you, convener. The Advisory Council, my amendments in this group, largely, as Ross Greer has already pointed out, change the name of the Advisory Council to a Governing Council. This is about building a stronger, more independent, more accountable system of governance around the Education Inspectorate to one that's trusted by the profession and the public alike. I think renaming the Advisory Council signals a fundamental shift from a body that advises to one that helps govern. This isn't just semantics, though, and I appreciate that members might consider that to be the case. And I take Ross Greer's point about the word governing, but this is about reinforcing the independence and legitimacy of inspection. If they're to lead real improvement, I think they have to reflect the realities of the classroom, not the corridors of government. They have to give teaching professionals a majority on the Governing Council as well, to ensure those closest to learning help shape how it's evaluated. And that's the main difference, other than the renaming amendments. That's the main different amendment in this group that I seek to press. Trust and inspection comes from transparency, credibility and practitioner voice, and these amendments take a vital step toward restoring that trust by creating the governance model that I think is representative, authoritative and independent. So Amendment 311 renames the Advisory Council to the Governing Council, and there are consequentials 314, 324, 325, 327, 329, 330, 335, 336, 343 and 352. Finally, the Amendment 326 in my name creates a majority on the Governing Council of teachers and college teaching staff to reinforce the fact that inspection function must represent and respond to the current and evolving needs of learners, teachers, college teachers and training providers. Thank you.
Thank you. I call Miles Briggs to speak to Amendment 172 and other amendments in the group. Mr Briggs.
Thank you. Convener, as with Amendment 129, quite a long time ago, debated earlier, and passed by the committee with the support of, kind support of my colleague Ross Greer, this amendment would require membership of the Strategic Advisory Council to include representatives of parents and carers of children and young people receiving education in relevant educational establishments. And I restate my argument around the positive contribution which parents bring to the school community and how actually their expertise can be drawn on. And I don't agree with the point the member put previously. I do think a parent being part of that advisory council can bring a lot of benefit, and I'm surprised people would argue against that. Increasingly, the inspectorate will be having parents raising concerns, and I think that gives that parental voice where it's needed and actually can shape many of the discussions and potential reforms in the future. So I will be pressing Amendment 172. I think it does, given that the committee have rejected a parent charter, does give that parental voice still, and I think that's important. So I move 172 in my name.
Thank you very much. Cabinet Secretary.
Convener, I thank the member for these amendments. In the bill as introduced, the core purposes of the Advisory Council is to provide the Chief Inspector with advice, support and challenge, rather than a formal governing role. I also recognise the benefits of having a range of independent voices within this. The current bill provisions require the Chief Inspector to establish and maintain an Advisory Council and to take independent decisions on its membership. The Chief Inspector must endeavour to ensure the Council is representative of those likely to be affected by inspection, and it is intended to set a fair and flexible framework for the independent Chief Inspector to work with. The provisions in the bill, as introduced, provide the right balance of core requirements and allow that flexibility in which the Chief Inspector can operate. However, I agree that there are a variety of different ways of achieving this, and I am open to discussing Mr Greer's Amendments 77 and 78 ahead of Stage 3 to ensure those are workable. We would need to ensure that there was no conflict between who appoints to the Council, given that Amendment 77 specifies ministers and Amendment 78 specifies that it should be the Chief Inspector. Additionally, I am concerned that the list as set out in Amendment 78 is too prescriptive and could exclude some groups that are affected by the Chief Inspector's work. And I note that the Children and Young People's Commissioner has also expressed similar reservations. I'm also concerned that any provision relating to members of the Council that are to be of a particular age group will have to comply with the law. However, I believe that we would be able to work together to develop a proposal which provides a level of reassurance in terms of those specifics, while still allowing flexibility for future-proofing. Now, Ms Duncan Glancy's... Yes, I will.
I'm very grateful, and I'm grateful to the Cabinet Secretary for indicating her willingness to work together ahead of stage 3 on proposals in this space. If I could just test her appetite for the specific element of 78 in relation to someone representing the interests of the staff of the Inspector, I'd be interested in the Government's position on that in particular, because I think there is broad consensus on other elements of this. When we're debating these issues in relation to Qualifications Scotland, there wasn't quite the consensus in that particular space, although it was a somewhat different proposal. I'd be keen just to check, in principle, the Cabinet Secretary's position on involving Inspectorate staff or those who represent their interests.
Cabinet Secretary.
Just to give Mr Greer reassurance supportive of that in principle, I'll come to address that point actually later. So, Ms Duncan Glancy's Amendment 326 stipulates that council membership must consist of a majority of persons who are registered teachers or college teaching staff. Now, I cannot support this amendment, which I would ask members to accept is too prescriptive and would also exclude other important voices from the council. Similarly, I fully support the involvement of parents and carers in the Advisory Council, which Miles Briggs' Amendment 172 seeks to achieve. I do have some reservations that prescribing this in legislation is not necessarily the best way to achieve a balanced and fully representative council, but I think it would be possible to do something in this space in conjunction with the changes Mr Greer is looking to make. Yes, I will.
Pam Duncan Glancy.
Thank you for taking the intervention, and I'll be really brief. 326 is just about providing a majority. It's not about entirely filling, and so there would be space for others on the council.
I recognise the point that the member makes, but I think the member, in delivering a majority, may deliver an unfair balance of voices, and the Advisory Council is meant to be advisory and not tilted to one perspective, if that makes sense. So there is a concern there that it will be in some way one-sided in relation to giving that advice and challenge to the Chief Inspector. Now, Ms Duncan Glancy's amendments on seeking the role of the Advisory Council to be that of a governing council, I want to talk to next. Convener, I thank Ms Duncan Glancy for the explanation on her amendments, but I'm not able to support that change. The intention behind the Advisory Council is to advise and to inform the Chief Inspector in the exercise of their duties, not to act as a governing body. I heard Ms Duncan Glancy's points about semantics, but I think in changing the name it would suggest it was something that it is not intended to be. And that name change could be misleading, it could cause confusion, particularly as no actual governance functions are being proposed. So I would ask members do not support the amendments in this group. I ask Mr Greer and Mr Briggs to work with me on a workable provision in advance of stage 3. And in doing so, I'm happy to assure Mr Greer that while we do need to be very mindful of the need to avoid undue prescription and inflexibility in legislation to ensure the Council will remain relevant to the Chief Inspector's work in the long term, I accept in principle that this will involve a greater degree of specificity than is currently set out in the bill as introduced, including looking at how we best give the guarantee of staff involvement that he is looking for in Amendment 78. Convener.
Thank you. I call Ross Greer to wind up and press or withdraw Amendment 77. Mr Greer.
Thank you, Convener. And as I said, grateful to the Cabinet Secretary for that offer to work with me on my amendments. So on that basis, I'm happy at this stage not to proceed with 77, 78 and 91. And on Pam Duncan Glancy's 326 about the majority of teachers or lecturers, if she were to press it, I would support it, but I would suggest that, much like our experience in relation to Qualifications Scotland Board, that would fall, and that perhaps as an alternative, if Ms Duncan Glancy wished to work with myself and the Cabinet Secretary in the space of finding an acceptable alternative to what I've currently proposed in 78, we might be able to get closer towards the position that she and I share in relation to the involvement of teachers and lecturers.
Thank you. Ross Greer seeks to withdraw Amendment 77. Does any member object? No member objects. Amendment 77 is withdrawn. I call Amendment 78 in the name of Ross Greer, already debated with Amendment 77. Ross Greer to move or not move?
Not move, Convener. The
question is that Schedule 2 be agreed to. Are we all agreed? Yes. We are agreed. At that point, I'll take a point of order from the Cabinet Secretary.
Convener, I would like to make a point of order for the record regarding my Amendment 73, which adds a requirement for a statutory review to be undertaken on the accreditation function, and I would like to offer my thanks to Ms Duncan Glancy for her eagle eyes on this. Earlier in the session tonight, I inadvertently moved this amendment, and in response, members also, I presume inadvertently, voted unanimously to support it. Now, as I promised to all members, I am entirely committed to cross-party discussions on the location and the scope of the accreditation function and the connected interest in the reviewing and quality assurance of qualifications ahead of Stage 3. It is absolutely not my intention for this amendment to preempt those discussions. I fully intend to look to adjust, remove or amend this provision at Stage 3 to reflect the outcome of these discussions, and I wanted to put that on the record and offer my thanks again to Ms Duncan-Glancy.
Well, excellent work by Pamela Glancy, and shaming us all for not noticing that, but I'm grateful to the Cabinet Secretary for putting that on record. Can I say I'm going to stop our consideration at this point? Members will therefore be aware that we have not completed our consideration of Stage 2. Therefore, the period for lodging amendments has reopened, and more amendments from Section 27 onwards can now be lodged with the Chamber desk, and the timetable for that is between now and midday tomorrow. Sorry, the legislation team, not the Chamber desk, if people were going to do that. I should say that concludes our consideration of the bill at Stage 2 today. I'd like to thank the Cabinet Secretary, her supporting officials, members and everyone else involved in tonight's meeting for their attendance. The committee will continue its consideration of the bill on the 7th of May, and I now close this meeting. Thank you.